is to curb any illegal or illegitimate practices, especially the black money rotation, I mean circulation. And that is why all these economic laws have assumed a lot of significance in last 7 or 8 years. We have with us Mr. Ashwani Taneja, who is also a chartered accountant and practicing advocate. Is also the ex tribunal member and is always willing to participate at any programs or organized by CA Institute, be it anywhere uh, across India. And we are fortunate to have him with us. He is right now, although at a conference in Udaipur, but we can observe his discipline and dedication towards the profession, that he has agreed to spare his time to address the fellow members even from the conference right in the morning on a Saturday morning. uh, Ashwani ji, we welcome you, and may I now request Alkesh to introduce the speaker, CA Ashwani Taneja, please. Alkesh, please.
Thank you, Kinjalji. I would like to introduce our today's speaker, CA and Advocate Ashwani Taneja. Shri Ashwani Taneja ji is the former member of ITAT. He is fellow member of Indian Council of Arbitration, New Delhi. He is fellow member of ICAI, ICSI, ICWA Institute. He had done masters in law. He practiced as a chartered accountant from 1995 to 2007 in varied areas of auditing, due diligence, tax planning, and litigation. Between 2007 to 2015, he practiced as a lawyer with firm Messrs. RRA Tax India, New Delhi, appearing before ITAT, High Courts, and Supreme Court. In 2015, he was elevated as a member of the tribunal, that is ITAT tribunal, and was posted at Mumbai bench, where he delivered more than 2,000 judgments covering wide variety of issues. Then in 2017, he resigned as a member of the ITAT and joined back to his old charm and passion, that is legal profession. Currently practicing again as a lawyer with Messrs. RRA Legal Daily, specializing in the area of anti-money laundering law, Benami law, Black Money Act, SFIO, and income tax, making representation before adjudicating authorities and appellate tribunal of Benami law and PMLA, ITAT, High Courts, and Honorable Supreme Courts of India. He is prolific speaker and has delivered presentation and lectures on different forums across the country regarding variety of issues on PMLA, Benami law, and income tax law. He have a good number of landmark cases argued by him before different courts or authored by him at the tribunal and have been published in the leading tax journals of the country. Friends, he is also very friendly and always available for the discussion on the issues relating to the subject. So we are really fortunate. Today we have such an versatile and learned speaker. Now I will request our today's speaker, Sri Ashwani Taneja ji, to start the presentation. Thank you.
Uh, Thank you, Alkesh, for the kind words, and thank you very much, Kinjal sir, for inviting me and for giving me an opportunity to share my thoughts. Whenever I am here back in Mumbai, whether physically or virtually, it gives me a lot of pleasure because my old memories, the golden part of my life, 2 years here in Mumbai, I enjoyed between 2015 and 2017. So they become afresh the moment I get connected with people of WIRC, whether in Mumbai or any part of the state. So, and moreover, I mean, it's nothing that I have got any special knowledge about the subject. I am just like one of you. The only thing is I am just focusing on this subject. So whatever my experiences are during the course of my representation before the courts, I just compile them. And as a bouquet mixture of these experiences, whether as a lawyer or as a judge or as a chartered accountant, or now again as a lawyer back. So I try to compile them and present it to you for uh, for the benefit of all of us, so that whatever things points we can pick up. I mean, for the cause of the profession, for the help of the society, or in the service of the nation. I mean, it is a profound privilege and pleasure for me.
Right. Uh,
Today's
so,
topic,
Ashwani ji, what I suggest is that we will first go through your presentation. While
yes,
we will, while we get the questions from the members, we will park this aside for the time being, and we will
yes,
try to address it towards the end. Is that okay?
right. Yeah, yeah. I think we can, that will be the right way,
Yeah.
because most of the questions and answers can be covered.
Right.
Some sound, background sound is coming from somewhere, I think. I
Alkesh,
don't know.
Alkesh, can you go on mute?
Yes.
Yeah. Yes. Yes.
So I think that will be the fantastic way of moving ahead, because it is quite possible that I have already
Okay.
designed my presentation in such a way that it is quite possible that most of the issues stand covered by the
Okay.
time we come to an end.
Correct.
So even if some things are still left, I think we could take it forward from there. So I mean, some of the issues you can compile and you can present at the end towards end.
Sure.
The
Sure.
only issue which I face mostly here is that some of the audience would be expecting me to remain stick to the conceptual framework of Benami law.
Mm,
Whereas those who have already heard me or those who have already read the Benami law, they will be expecting me to deal with practical aspects, and
right.
somebody would be interested in dealing the complex issues. So I think, I mean, since I have already delivered one or two presentations in WIRC also, so I think the better way would be I should take up the practical aspects, and wherever any conceptual requirement takes place, though little bit I will try to cover, but apart from that, whatever Kinjal Saab is left and you think it is needed, we can take up at the end also.
Perfect. Perfect.
So let us
Perfect.
begin with the practical aspects, so that at least we are able to understand how the practically things are happening in this regime.
Right.
That is
Right.
how I plan to proceed.
Yes. Yes. Please.
So exactly at 100 we are starting. Our participants have touched the figure of 100 just now. Anyways, so uh, thank you very much for coming in the Saturday morning and giving me an opportunity to share my thoughts with you. Benami law. This law, this alone law has brought out a turnaround in the framework of the working of the officers, in the framework of working of the manner of doing business, the thought process of the citizens of the country, and the way we live our life. You must be wondering that why I am saying that the way we live our life, how will we understand this from this Benami law? Yes, friends. I mean, I will demonstrate it that with this small piece of law. I mean, not only that, we will understand our professional framework, we will also understand how to live life. You must be wondering how. You know, sometimes I wonder that if we analyze our own life or the people who are living around us, we'll find that we are living a life which cannot be said to be a realistic life. We live by and large a Benami kind of life. So, with the help of this law, maybe we are able to understand how to get rid of this Benami life and how to live real life. We enjoy a lot when we live real life. And howsoever successful we may be, but so long as we live in a Benami framework of living, I mean, that does not give us a truly blissful satisfaction. That is what that is how I believe. For example, somebody was asking me that, sir, how to define Benami, the concept of Benami in one line. So I take this example that symbolically speaking, the problem comes to a human being when he gets disconnected from the supreme power. When he thinks that he is different from the supreme power, that one, if he is different and gets himself, makes himself, renders himself disconnected, then the problem starts coming. Problems are always there, but then he finds difficult to cope up with the problems. So long as he remains one, so the problems come, problem goes, and he is able to absorb everything in life, all experiences, good and bad, all experiences of life. So when the problem of duality comes, meaning thereby he is different from that supreme, so dual, instead of one, they become two. then the problem comes. अभी भी बैकग्राउंड नॉइज आ रही है, कहीं से म्यूट करने की जरूरत है शायद, अगर आप कर दें तो सभी तरफ से. So the problem comes when there is a problem of duality. Similarly, absolutely similarly, under Benami law also, the concept of Benami gets triggered when duality pitches in, comes in, checks in. What do you mean by duality? For a property, there should be one owner. There is always a one owner, unless there is a co-owners, of course. So there is one owner, that is the registered owner, that is the real owner, that is all kind of owner. But if this ownership is divided into two parts, that is, registered owner is say Mr. X and the real owner is say Mr. Y. So when the ownership is bifurcated into two parts, the problem of Benami emerges. So long as there remains singularity, no duality, the same person, that is say Mr. X, only he is the registered owner, he enjoys the rights of a real owner. There is no problem. There is no problem at all. Benami cannot come into play. So conceptually speaking, the problem of Benami is faced only when ownership is passed, divided into two parts. How does this problem arise? And where and why? The the reasons for it goes far back, more than 300-400 years. I mean, in ancient times, Benami transaction used to happen. The evidence of which is from this very fact, the name Benami we have chosen. You know, this word Benami, this is not from Hindi language or from, I mean, English. This is actually from Persian language. So that means Benami word came up here when uh, when Mughal rule was there in our country, because at that time only there was mixture of Arabic and Urdu language. Persian language was in vogue in our country. So the word Benami came up at that time. That means Benami transactions were happening at that time. Not only that, you would find that even in British rule, Benami transactions were happening. Not only happening, these were expressly allowed by the legislation, that is the British rulers at that time, by an express and specific legislation through Indian enactment of Indian Trust Act 1882. So it was enacted in 1882. So certain sections of Indian Trust Act 1982, 1882 prescribed that if it does, the rights of the real owner shall be protected. So there was no punishment, rather there was an encouragement. You can read section 81 and 82 and 94 of Indian Trust Act 1882. So you'll find that what I'm saying is correct. At that time also Benami transactions happened. Not only that, our own Indian Income Tax Act, that is Income Tax of 1961, that also allowed Benami transactions. If you read section 281 at that time, that read at that time that yes, Benami transactions can happen, and if Benami transactions is done, the only requirement is that it should be transparently disclosed to the government. That's all, to the jurisdiction chief commissioner. If these are disclosed, no problem. You can do Benami transaction. You can buy the property in Benami name. So that means there was a thought till 1961, even in 1961, that Benami transactions are some part of the customary practices and that can be allowed. But all these thoughts got changed in 1988 when some ordinance was brought and which was made an enactment also, whose name was Benami Transaction Prohibition Act. It contained only 9 sections at that time, and it provided that no person shall do Benami transaction at all. Total embargo was put, and if anybody does it, there was not only punishment but also attachment of the property, even in that time. And not only that, all these sections which I mentioned before you of Indian Trust Act and also of uh, Income Tax Act, Section 281, etc., they were all repealed. So, meaning thereby there was full embargo. Endorsement from the government to do Benami transaction was over. Rather, there was a total complete prohibition in 1988. But you must be wondering then what happened now, because now, in fact, that 1988 Act remained in inactive mode. The implementation agencies were not created. So, since implementation agencies were not created, it remained toothless, प्राण रहित शेर, जिसको आपके दरवाजे पर बैठा दिया और जब 2016 में आप दरवाजे से बाहर निकले तो वो उसमें लाइफ डाल दी. So suddenly amendment act was passed, and this act was overhauled, and new implementation agencies were created, whom we call it Benami Prohibition Unit, which is part of the investigation wing of the income tax department. And that is how birth of initiating officer took place. And that is how all along in the last 4 years, Benami actions under Benami law have been taken, whereby various properties have been attached. And one of the first such popular properties having been attached, which brought to the knowledge about the introduction of new Benami law, was when the property of Shah Rukh Khan was attached. So property of Shah Rukh Khan was attached, not this Mannat wala bungalow. I am talking about that Alibag bungalow. When this was attached, so then things that there was a lot hue and cry. So I also got a call from Economic Times, wherein the correspondent Mr. Sugata Ghosh, he asked me, Mr. Taneja, how would you summarize this new law? So at that time I said this is an unguided missile, maybe unwittingly created and loaded with nuclear arsenal. So after three, I mean, I saw the cutting in the newspaper. I mean, the story in the newspaper next day, and I found that my views have been published as it is. So I thought, I mean, as if I have said something excess which should not have said. I read the law again, and I found no, what I am saying is actually absolutely correct, because rather something more can also be said the way law has been drafted. And he calls me again after 2 years, and he says, sir, whatever you said is now proving to be all right, because now this law has starting hitting, uh, I mean, even the listed companies. So since listed companies are also being hit, I mean, it is really has become now unguided missile. So sir, after reading this law, I see only one thing, that now we must have basic awareness of this knowledge, each of us. Not only because we may do practice in this area, that could be a major reason, but there are many other reasons also. And the other reasons are that whatever transactions now, whether you as a person or your client or some of your family members would be doing, I mean, all this should be vetted from the point of view of this law also, whether transactions have already been done, or transactions in the pipeline, or transactions to be done in the future. So unless and until we become aware about this law, it may be difficult for us to guide our clients that how can you avoid the triggers, the violation of this law, because violation of this law will definitely is going to cost very, very dearly. So it is imperative for us to understand the nitty-gritties of this law, the fundamentals of this law, the practical aspects of this law, and be guided in during the course of our profession. So, friends, with that, I will begin this deliberations on practical aspects. Before that, Kinjal Saab was saying that it would be useful if I share some conceptual framework also. So, I will into few minutes only. I would like to share some of the fundamental aspects before I touch upon the practical aspects. As I said, that Benami comes in when duality takes place. So, Benami transaction has been very, very widely defined under the Act. Section 2(9) defines Benami transactions, and there are four clauses: clause A, clause B, clause C, and clause D. So these the definition clauses has been defined in such a sweeping manner that it becomes very, very difficult for any situation to get out of it if there is any Benami event involved. All possible life situations have been envisaged, and in the most sweeping manner, rather there is overkilling in these clauses. So something more even other than Benami has been attempted to be roped in. Once we read A, B, C, and D, and all. So clause A is a very classical clause which simply says if the consideration of a property has been paid by, say, Mr. X, and the property has been transferred in the name of Y, and Y becomes a registered owner, but X remains the real beneficial owner. The benefit directly or indirectly accrues to Mr. X. Consideration has been paid by Mr. X, and registered owner is Mr. Y. Then Y becomes Benamidar, X becomes beneficial owner, and the property so transferred in the name of Mr. Y becomes Benami property. So that is what clause A talks about. Now, clause B, clause C, clause D, they are also worth reading, because clause B simply says if a property is transferred in a fictitious name, then it becomes Benami. Any property held in fictitious name is Benami. Now, fictitious name would be, suppose somebody has purchased property in the name of a goddess, god, pet, somebody who is not recognized as a person in the eyes of law. Is fictitious. So any property by the very fact that it is in fictitious name becomes immediately Benami. And the consequences are very severe that I'll discuss. The moment it becomes Benami, that what will happen, that is what we are here to discuss today. Then clause C says, in case a person is not aware about the knowledge of the ownership of the property. Suppose Mr. X is the owner, registered owner, and he says, I don't know if I'm owner of this property, of any bank account, of any property, then that property by this very reason becomes Benami. if, if the registered owner feigns ignorance, that itself makes the property as Benami. See how straightforward the law is, how crisp the law is. But under prohibitory laws where the deeming provisions are attracted, I mean, such kind of crisp laws are not interesting, but they are very, very disastrous. Then clause D is really very, very important. Very, very important clause D, which is being trying to be hit, under Benami law, which says that if the pair of the consideration is not traceable or fictitious, pair of the consideration is not traceable or fictitious, then the property is Benami. Now, I mean, many questions would arise when we will read these sections. Many, many questions would arise. Not one, but hundreds of questions would arise. Because, I mean, even if a person is a valid registered owner and the consideration was paid properly at the time of the transaction, but if today the person has gone somewhere missing or is not traceable or does not want to come before the authorities, I mean, why the present owner should be disturbed for this reason? How can the owner of a property for all times to come ensure that the person who paid the consideration is always available, is always traceable, not only available, traceable, and is brought to the task before the authorities? I mean, how can he be made responsible for the conduct of the other? But the law is what it is. So clause D is really, I mean, prone to a great misuse, misadventure by very many authorities. So it needs to be rationalized. And you must have heard by now that this treatment about so-called bogus loans or bogus share capital, I mean, all those wherever the additions could be made under the income tax proceedings, or even if it could not be made, those are being now roped in under the net of Benami law by treating those assets as Benami assets. I mean, all these share capital Benami, consequential proceeds Benami, properties Benami, etc., etc. And all sorts of experiments are being done there. So these were the four clauses of transactions of Benami. By and large, you must have read, I believe, and with that presumption only, I am proceeding to touch upon the practical aspects for which we have gathered here today. Now, my first issue is what are the consequences of Benami transaction? My sound, my voice, etc. is all right. Can somebody confirm, or should I increase or decrease or what?
It is perfect, sir. It is perfect.
All right, thank you. So, consequences of Benami transactions. What are the consequences? Let us begin from there. The first consequence is attachment and thereafter confiscation of Benami property or proceeds thereof. You know when the attachment takes place? Attachment takes place immediately. Meaning thereby, we are habitual of facing proceedings under income tax. So that is why it is a matter of great shock and surprise for us that here attachment is done immediately. In the income tax proceedings, how the attachment is done? Maybe once the demand is crystallized, demand is not paid, and maybe after decades, sometimes in the lifetime or the fragment of the lifetime, this attachment proceedings begin. Here, the attachment proceedings begin with the notice proceedings. When the proceedings begin, it begins with attachment. How? Because the law has been framed in such a manner that whenever initiating officer wants to begin the Benami proceedings by issuance of recording of reasons and issuance of notice under section 24(1) of PBPT Act, then he has been given powers to simultaneously make provisional attachment under section 24(3) to avoid any transfer, any attempt to transfer any such Benami property. So whenever 24(1) notice comes, also comes along with it the provisional attachment order. So, and because of that provisional attachment order, it sends shivers to the spine of the person, to the noticee whose property is attached. Because suddenly one fine morning he will come to know that his property has been attached on the ground that property is Benami. But having said so, the 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 provisions with regard to the provisional attachment have been made to be applied in special circumstances, not as a matter of general practice, but they are being used not sparingly but as a rule, whereas these should have been ruled as exception only in exceptional circumstances. That is what the language of section 24 bracket 3 says. If we read the language, you'll come to know it says that where the initiating officer is the opinion that the property is likely to be alienated. So there have to be circumstances, there have to be some findings, some factual material that property is likely to be alienated. Only then 24(3) should be triggered. But now probably these words have been forgotten. These are omitted to be read. These are ignored, disregarded. And as a rule, as a practice, wherever 24(1) is issued, 24(3), that is provisional attachment order, is also invariably issued. That is number one. Number two, there are other things also which I'll discuss. That it is a matter of provisional attachment order, not confiscation. Because confiscation of the property takes place only after the appeal is decided by the appellate tribunal, and thereafter fresh proceedings are done by the adjudicating authority, and thereafter only confiscation proceedings can be done. So friends, though confiscation is not being done, then the question must be arising in your mind, all right sir, confiscation is not being done, only attachment is being done, then what is the problem? So what kind of rights are restricted, or what kind of I would say hassles are created, what kind of embargoes are put, what kind of problems arise, etc., etc. So that is what we will discuss today, that what are the consequences of attachment also. Before that, let us read first of all the total consequences of a transaction being treated as Benami or a property being treated as Benami. Then the second consequence is prosecution and rigorous imprisonment of the persons who are found guilty of offensive Benami transactions, and fine up to 25% of fair market value of the property payable by each person held guilty of offensive Benami transactions. So these transactions have been divided into two parts: transactions which are done post 1/11/2016 when the new law was brought in, and the other which were prior to that. So prior to that are to be prosecuted under section 3 as per old provisions, and subsequent transactions are to be prosecuted under section 53, which prescribes about fine up to 25% of market value, etc. Then there are other things also, for example, prosecution for false information. So there is a rigorous imprisonment for 6 months to up to 5 years for any person knowingly giving false information, and also fine up to 10% of fair market value. So fair market value at the time when transaction had taken place. At that time, whatever fair market value was there, value of that time at 10% of that on each such person. This the middle clause also, that is 25%. This also will be applicable on each such person. It means there would be Benamida, there would be beneficial owner, and then there is also a third category which has been created: a person who has abetted, a person who has given them the advice to do Benami transaction, or person who has led them to do Benami transaction, with whose help the Benami transaction, or under whose guidance the Benami transaction has been done. I mean, that person has also been treated at par with Benamidar and beneficial owner, because the punishment and the consequences are same. That is prosecution and 25% of fair market value of transaction. So these are the 3 or 4 broad consequences which arise if a property is treated as Benami property. Then let us further deal in detail that how the attachment is done. Provisional attachment is done by the initiating officer under section 24(3) for a maximum period of 90 days. Because IO's job is over in 90 days as per the provisions of section 24, and because at the end of the 90 days, then he has to decide whether the property is Benami or not. If according to the IO, the property is not Benami, then he will release the property from attachment. But in case he believes that property is Benami, then uh, he can he has to pass an order continuing the provisional attachment order under section 24(4) till the adjudication is done by the adjudicating authority under section 26(3). So these two things happen at that time. If in case he finds that yes, this is to be continued, then he has to pass a reference under section 24(5), which is to be sent to the adjudicating authority presently located at Delhi. So on the basis of this reference, then the adjudicating authority decides whether the property Benami is or not. The hearing takes place and 1 year time is given to the adjudicating authority. Then within this period of 1 year, the adjudicating authority decides whether this property is Benami or not, after giving opportunity of hearing to all these parties, that is parties who have been made defendant by the IO and any other party who may be interested, and IO's counsel also. So that is how then adjudicating authority decides. As I said, friends, that 24(3) is being used as a practice disregarding the requisite mandatory conditions. So I would submit before you few important things, facets, which are being ignored by the IO while making attachment, and that is why this provision is coming as a very very harsh provision. I mean, before the people, public is being really, I would say, getting disturbed. The way the law has been drafted is that the requisite conditions for making provisional attachment is that first of all, notice under section 24(1) is issued. That is being observed in most of the cases, except few cases. They are even without 24(1), they have issued 24(3) in certain properties. Now, second thing is that 24(1) can be issued to the benamidar and beneficial owner, whosoever is holding the property today. But 24(3) has to be issued if the possession of the property with the person held is Benami. Suppose property allegation is that the property belongs to X, which was transferred to Y. So Y was Benamidar. But the situation is that Y had also sold the property to a bona fide purchaser and the property to Mr. Z. To Mr. Z, and property is today held by Mr. Z. Then property is in possession of Mr. Z. So on the date of issuing a provisional attachment order, IO has to ensure that property is held Benami in the hands of present possessor, that is Mr. Z in this case, which is not being done, friends. So once the property is treated as Benami, or say X and Y are identified as Benamidar and beneficial owner, then property is attached without even any effort on the part of the IO to find out who is the person presently in possession. And that is how the harsh consequences are taking place, because Z is unnecessarily disturbed. Then the next condition, as I mentioned with you, is before you, is that IO fears alienation of the property during the period specified in notice. So period specified is in say 15 days. So only if he thinks that under section 24(1) he will immediately alienate the property, only then. If the property is say already in control of the income tax department, so if the property is already in the control of the income tax department, then there is no necessity of making the provisional attachment under section 24(3). But this condition is also not being fulfilled in many cases. Then the next important is prior approval of approving authority. Now here I have to say a few lines. Why this provision has been created? Prior approval of approving authority. What is the purpose for this? The purpose of making this enactment of prior approval of approving authority, friends, is that to check that powers are not misused and the actions are taken only in right and deserving cases where the action should have been taken, and not any in bona fide or innocent cases. That is the whole purpose. So meaning thereby The minimum that is expected from the approving authority while giving his approval or sanction or satisfaction is that the approving authority would go through the material, would while giving, and if he's satisfied the material, satisfied on the reading of the material, then go give his finding that what material he or she has gone through, how so and so property is benami, how so and so persons are benamidar or beneficial owner, maybe in few lines, but he will have to say this ki, yes, this is benami under this clause, and so person is benamidar and beneficial owner under this clause. But in majority of the cases, friends, I have seen that no such reasoning is given. The approval, so-called approval, is given in a highly mechanical, blindfolded manner, which vitiates the entire purpose, frustrates the entire purpose of bringing out this requirement under the law. Then what is property here? This question is asked, so whether the property will include also movable property, whether rural property can also be included, or only it is movable property only. In fact, very wide and wild definition has been given of the term property. If you will read, it says property means assets of any kind, whether movable or immovable, tangible or intangible, corporeal or incorporeal, and includes any right or interest or legal documents or instruments evidencing title to or interest in the property, and where the property is capable of conversion into some other form than the property in the converted form, and also includes the proceeds from the property. So kindly see, it is including not only converted property but the proceeds of the property also. Converted means when physical conversion takes place. From raw material it becomes finished goods, from gold biscuits it becomes jewelry, etc. It includes everything. Then proceeds also. Suppose property is sold by the benamidar, then whatever proceeds he receives, that is also liable for attachment because it is property. Then Benami property. What do you mean by Benami property? Benami property means any property which is subject matter of Benami transaction and also includes uh, the proceeds from such property. So again, the proceeds from such property has been included here. Effect of attachment. You might be wondering that, sir, all right, attachment is done, confiscation has not taken place, but what is the effect? Can we stop? Should we stop using the property, etc., etc.? There are many such questions which come to our mind. Whether the rights to use property come to an end only, or only rights to transfer the property becomes restricted, or both become restricted. What is the true position of law in this regard? In fact, if we read the definition of the word attachment, which is given here under Benami law itself, we will come to a conclusion that what the right position here is. Attachment means the prohibition of. Can you see my slides now? I am changing the slides. Is it visible, all the slides?
Yes, sir. Yes, sir.
All right, all right. So attachment means the prohibition of transfer, conversion, disposition, or movement of property by an order issued under this act. So meaning thereby, nowhere they have restricted the right of usage of the property, right of enjoyment of the property. So only embargo is that property will not be transferred. Suppose you are having house property, tenants are living. So whether tenants have to be evicted? No. What will be happening with the rentals? So since right of usage is allowed, rental will be earned. So here it is different from PMLA law. Then suppose the car is attached. Now car is being used for running on hire. So whether it can be used, kept on using on running on hire? Yes. Only its transfer is restricted. Usage is not restricted. And if we read section 57 also, from reading of section 57 also makes it clear that what becomes void is transfer, not usage. Then confiscation, friends. Then even after the confiscation, then what happens about the confiscation? What happens if once the confiscation is done, then where an order of confiscation has been made under section 27(1), all rights and title in the sub property shall vest absolutely in the central government free of all encumbrances. So meaning thereby on confiscation only all rights and titles in such properties. So title के साथ साथ rights कहाँ vest होंगे? Only when confiscation is done. So before the confiscation, not all rights, only rights with regard to title only will come to an end. Suppose shares are attached. What shall be the complication? What shall be the implication of the same? Whether there will be restriction on the right of voting, whether restriction on right to participate in the shareholder meeting, right on restriction on right to receive dividend will come to an end, restriction on to pledge shares will come to an end, restriction to sell transfer or shares will come to an end. What is your thought process on this? If we apply the same fundamental, we shall find that whenever the property is attached under section 24 bracket 4, only thing which should come to an end is right of transfer. So right of voting is right of usage, right to participate in shareholders meeting, usage, right to receive dividend, usage. So only thing is right to pledge shares tinkers with the title of the shares. So right restriction on to sell and transfer, also title. So meaning thereby, according to my understanding, first three rights shall not be restricted. The bottom line two rights, that is restriction to pledge shares and restriction to sell transfer shares, will come to an end so long as the property remains attached. This was also just 1 second. Yes, this was also held by Honorable Supreme Court in the case of Balkishan Gupta and others versus Swadeshi Politics Limited. Attachment of shares do not deprive the shareholder of their right to vote at a meeting and other allied. Now, this was not given in the context of Benami law. There are other laws also when shares used to be attached. So in general context, this judgment was delivered and the principles are the same. I think we can pick up from this judgment, celebrated judgment of Honorable Supreme Court. Then what about attachment of land and building? Again, right of usage of property to keep tenant, receive rent, right of construction development, right to mortgage, subdivision of plots, entering into development agreement, right to sell. So from right to mortgage, I think the rights will be restricted. Other rights will be kept intact. So first four rights remain intact. Remaining four rights, that is bottom four rights, that will be restricted according to my understanding. As I said, confiscation does not happen automatically. For confiscation also there is a process which is defined. Confiscation to take place after the order of the adjudicating authority is passed, appeal is filed, appeal is decided by the tribunal. Thereafter, adjudicating authority gives opportunity to the persons concerned before the confiscation, and thereafter only confiscation can take place. And only then all the rights and title in the property shall vest absolutely in the central government. And it is very, very important to know that no compensation is payable in respect of confiscation by the government. One important question arises in the example which I gave. Like suppose X is alleged beneficial owner, Y is Benamidar, and property is presently held by Z, who purchased bona fide from Mr. Y. What will be the consequence of such transaction under Benami law? Whether property from Z will be taken away, attached and then confiscated under Benami law, or his rights will be remain protected. So friends, for this, I think the answer is very, very plain and simple. When the law itself is saying that the property includes proceeds also, so as far as Y is concerned, the property is now proceeds in the hands of Y, not anything else. That is why this proceed, the word proceeds have been included in the definition of the term property. And that is the whole purpose. And more specifically, once provision has also been created, that is section 27 bracket 2, which gives protection to the bona fide purchaser. But there should be two conditions attached to it. That firstly, that the transaction should be for adequate consideration. Number two, the the purchase should have been prior to issuance of notice under section 24(1). And number three, the purchaser had no knowledge of the Benami transaction. So, as far as adequate consideration and no knowledge is concerned, the next question which arises is whose burden will be to prove these two conditions are fulfilled or not fulfilled in this case. Now, this is a very, very tricky situation. And that this issue came up before the honorable tribunal, and we argued on the basis of certain judgments that my lord, kindly see in the burden to prove a transaction as Benami is upon the initiating, upon the person who alleges that transaction is Benami, under the well accepted principles given by uh, honorable Supreme Court and read with the final principles of Indian Evidence Act. So therefore the burden to prove that these two conditions are not fulfilled here, I mean, it should be upon the IO. That IO should say that yes, since that consideration is not adequate and the purchaser had knowledge about Benami transaction, only then he can make attachment in the hands of Z. So there was a lot of resistance from the department, but finally, Honorable Justice Manmohan Singh, sitting as chairman of the appellate tribunal of PMLA and Benami law, he agreed with my contention, and very good judgment. Two judgments have been delivered, which are available on the site of the tribunal, namely Kavita Infrastructure and other was Bargo Township from Rajasthan, from Jaipur probably, and this Kavita Infrastructure is from Bombay only, from Pune or Bombay West only. So these are very, very good, well-reasoned judgments. Both are available on the site of the tribunal. These can be read. So after reading these two judgments, many more things will become clear. And the harassment, unnecessary harassment, which is being done to the bona fide people, that can be avoided taking use of these two judgments. Then about interplay, I think interplay with income tax, etc. If you'll permit, we can take it up after finishing PMLA law. We can straight away take up slides with regard to interplay between all these laws, how all these laws are connected with each other. In the meantime, let me cover up the most practical aspects which are given here. Prosecution. Now, friends, the prosecution with regard to the present transaction has been prescribed here under section 53. It talks about three things: the situation in which a person may be held guilty of for offense of Benami transaction, the persons who may be held guilty for Benami transaction, and the quantum of punishment in the form of imprisonment and fine. Now, three situations have been given where a person may be held guilty of Benami transaction. One, where a person enters into Benami transaction in order to defeat provisions of any law, or to avoid payment of statutory dues, or to avoid payment to creditors. Now, these are very, very wide, it's quite sweeping, because in order to defeat provisions of any law, there are hundreds and uncountable laws. So there could be a violation of any law, knowingly, unknowingly. So it becomes a reason to prosecute that person also. Then to avoid payment of statutory dues, it is not talking about taxes only, it is talking about dues. Dues could be stamp duty, gift tax, it could be octroi. I mean, it could be anything. Then to avoid payment of creditors, and it is not talking about statutory creditors. So therefore, it will include trade creditors also. So if, I mean, a person is withholding payment of trade creditors, the trade creditors may report to the concerned authorities all the transactions of any such person, alleging that these transfers have been done to avoid payment to creditor. So meaning thereby the properties which a person has transferred, he may say, no, these are Benami transactions. He has, in a Benami manner, he has made transfer of these properties so that he is left with no money, and so that he can avoid payment to the trade creditor like me. So this kind of allegation can be made. It will be difficult to defend if the facts are like that. Then who are the persons who may be held guilty? The beneficial owner, the Benamidar, these two persons you know, and kindly know about third person also. Any other person who abets or induces any person to enter into Benami transaction. Now, whether the plain simple guidance will also be amounting to inducement, it may be yes, depending upon the facts and circumstances. Guiding a person, helping a person may come under abatement and inducement. So, therefore, everybody should be very careful while making any representation, while making any advisory, while giving any guidance to anybody, be it is your client, friend, family, anyone. Quantum of punishment. Person found guilty of offense of Benami transaction liable for rigorous imprisonment for 1 year to 7 years, fine up to 25% of fair market value of property. You know who are the person who is liable? All these three persons, not only one and two, all these three, third one also. Then there is a penalty for false information also, as per section 54. Then who are the authorities under the law? Following are the authorities under the law about whom we should know. Firstly, initiating officer, then approving authority, then administrator, the adjudicating authority, appellate tribunal, and special courts. So, a special court means the court who will do the prosecution. Appellate tribunal is not income tax appellate tribunal, it is a separate tribunal, which is tribunal of SAFEMA, COFIPOSA, NDPS, PMLA, that is anti-money laundering law, and also made the tribunal for Benami law, which is located in Delhi. And good judgments have been passed by the tribunal. Only few judgments have been passed, but they are very good. They are laying down the final principles with regard to burden of proof, etc. Now, there is one amendment which has been made with regard to adjudicating authority in the Finance Bill 2021, which was delivered on February, first week of February only, 1st February. So, friends, this amendment which has been done is now suggesting that the adjudicating authority, which was hitherto the common adjudicating authority with PMLA, where the matters being heard in by way of division bench by Shri Tushar Shah and Vinodanand Jha, or along with Mr. D. Singhai. So Mr. D. Singhai retired, and on 12th February, Mr. Tushar Shah also retired. So only left with is Mr. Vinodanand Jha, who was a former chief commissioner posted in Mumbai only. Now that authority is being shifted. The jurisdiction has been shifted from 1st July to the competent authority. Now, who is this competent authority? Competent authority is the authority under SAFEMA, whose job is to make attachment of the properties under COFIPOSA, SAFEMA, NDPS, etc. So it acquires the properties. It does the job of enforcement, acquisition of the properties of these offenders under these laws. Now that property will adjudicate the action done by the initiating officer. So 3-4 questions immediately come to our mind. Then firstly, that is a single person. Here it was division bench. So something which within the framework of the law has been envisaged to be done by the division bench, why being assigned to single person? Number one. Number two, in any case, that authority is in the job of making attachment. So it is, how can it act like a quasi-judicial authority or act like a judge, that it will adjudicate upon the order passed by the initiating officer under different law? So there it does the enforcement acquisition in a very strong manner, in a very harsh manner, in a very strict manner. Now the same very authority how it can balance its mind and does the adjudication part like that of performing role of a judge, and does the adjudication of the orders passed by the initiating officer. So there are many such questions which are arising in our mind. I mean, touching upon the fairness of this kind of provision, uh, uh, I mean, illegality of this kind of provision, unconstitutionality of this kind of provision. And I have recently, written an article on it. That article has been published a few days back only by Chamber of Tax Consultant in a recent journal, wherein I have given my thoughts on how ineffective such kind of authority would be, how harsh it would be, because there will be total non-adjudication of mind now, non-application of judicious mind, because IU has been given period of 90 days only. So he will work like a pure executive. He will simply make attachment. He will not have time to making judicious application of mind. In any case, his role is also not perfectly like that. Now, after that, some expectation was there from the adjudicating authority. That role has also been assigned to an executive only. So the judicious application of mind will not take place there also. Now the only thing judicious application of mind, where the judicial application of mind will start after 1.5 years, would be with the tribunal. Tribunal is now presently headed by left with the one person, because Justice Manmohan has also retired. So that tribunal is also overburdened. How it will also have the occasion, though this is a very good institution where independent decisions are taken, though the tribunal is within the same ministry, that is Ministry of Finance, wherein all these departments are there: ED, BPU, income tax. So within the same ministry, again that tribunal will be performing the role, but that too, it is highly overburdened. So the only thing that will start on merits, where the things will start on merits, will be not below High Court. So High Court, to what extent they will be able to apply mind with focus and specialization, keeping you the burden on already on high courts. This is raising a big question mark on maintaining the fairness in the legal system, on ensuring that the people will not be unnecessarily disturbed. So big question marks are being raised in all these things. Let's see how the things happen. It is like anybody's guess. Then powers of the authorities. Friends, as far as powers are concerned, enormous powers have been given of making investigation, inquiries. So powers are given under section 90, wherein the authority can make any inquiry. It can issue summon, it can record a statement, etc. But power of search is not there. But even if it is not there, it is being availed. How? Because it is part of investigation wing. Since it is part of investigation wing, it can, the investigations are done by way of search and surveys, and all this material gathered from there is supplied to the BPU. So that power is being enjoyed indirectly by the BPUs. Now certain which are lesser important things. What is the role of adjudicant authority? My slide is open before you. I have flipped through many slides. Which slide is open before you now? Anybody can comment, please.
The section 26.
Yes, all right. If somebody is saying we cannot see slides, we cannot see slides at all. In the chat box, if you see.
सर हम लोग अटेंड कर रहे हैं उसको, अभी ओके आ गया.
अच्छा, नहीं सब कोई भी नहीं देख पा रहा था या सिर्फ मैं नहीं,
नहीं कुछ लोगों को नहीं दिख रहा था, बट नाउ इट इज विजिबल.
ओके, ऐसा कैसे हो सकता है कि कुछ लोगों को नहीं दिखे?
हाँ, वो हम लोग भी नहीं समझ पा रहे थे. मेरा वही WRC में वही बात चल रहा था.
सर इसमें क्या है कि आपने उनका वीडियो फुल स्क्रीन कर रखा है, पीपीटी छोटा करके रखा है.
मैंने ऐसा किया है? मेरे पास तो ऐसा कोई कंट्रोल ही नहीं है.
नहीं, आपने नहीं किया है, सब पब्लिक ने किया होगा.
हाँ, उन्होंने किया होगा, वो तो रिस्पेक्टिवली हर एक के पास अपना वो होता है ना ऑप्शन.
वीडियो है ना,
उसको ऑप्शन
पीपीटी छोटा करके रखा था, इसलिए नहीं दिख रहा था. बाद में मैंने पीपीटी बड़ा किया, फोटो छोटा कर दिया, तो मुझे भी दिख रहा है.
ऑल राइट.
Okay, thanks Vaibhav.
Okay, so anything, if anybody is facing any problem, please allow them to raise their voice. You can also share with us any problem. Maybe my speed is more, or my diction is lesser loud or more loud. You can please share all these things with me. Anyways, now what is the role of the adjudicating authority which has been prescribed under the law? For example, under Income Tax Act, Income Tax Appellate Tribunal can decide the order, pass the order as it thinks fit in the interest of justice, whether what kind of income is accessible, etc., etc. And in that respect, it can pass any order as it thinks fit. Here, the role which has been assigned, the power which has been given, is only to declare a property Benami property or not a Benami property. That's it. So after hearing the parties, the adjudicating authority shall decide that the property is Benami or not. So far, so good. No problem in that. But the problem is, this should not be the only role. It should be one of the major roles only. There are other roles. For example, whether the principles of natural justice have been followed or not. Order has been passed by the initiating officer in accordance with law or not. Jurisdictional fundamentals have been kept into account or not. I mean, whether the adjudicating authority can go into all these questions, should go into all this question. I mean, because of this improper drafting, this could also be a serious issue to be deliberated. Though I am of the plain opinion that to declare property Benami or not, all facets should be seen and should be dealt with properly, keeping in view the finer principles of law as well as constitution of our country. But I mean, I think proper clarity is required under the law, maybe through the legislature or maybe court made judgments. But so far, the authority has been passing the judgments in highly abstract manner, not going into the legal and jurisdictional issues because some other reasons. So confiscation, I have already dealt with this part. Then we can skip this part. How the jurisdiction of the initiating officer is decided. Any clue on that? Whether the jurisdiction is decided on the basis of location of Benami property, location of Benamidar, or location of beneficial owner. CBDT SOP says it could be based upon any of the three. So it is quite possible somebody, Benamidar is in Bombay, beneficial owner is Jaipur, property say is in Calcutta. So any of the three officers located in these cities can touch upon this. Suppose all three initiates, then what? Then board says who has initiated first will have the jurisdiction. So a kind of rat race has been created. Now this is worth reading as SOPs by CBDT by notification dated 10th August 2017. Jurisdiction of the initiating officer, approving authority and administrator. Section 3.1 states that no person shall enter into any Benami transaction. The scheme of the act revolves around consequences of violation of this section. It is therefore appropriate that the jurisdiction is assumed by a BPU when any of the three limbs, that is Benami transaction, Benami or beneficial owner, falls under, is assigned territorial jurisdiction. This I have already read. We can skip this. Few important facets I would like to dwell upon before you. Now this one of the sections says that this Benami law, this PBPT Act shall have overriding effect. It says the provisions of this Act shall have the effect, notwithstanding anything inconsistent therein contained in any other law for the time being in force. And section 60 says the provision of this Act shall be in addition to and not, save as hereinafter expressly provided, in derogation of any other law for the timing in force. So two things is saying. Number one, it is additional law and it has supersession effect. It is not substitution law, it is additional law. So one thing becomes clear when it says additional law, that there could be circumstances. Somebody was asking me that what is the interplay between income tax law and this. So there could be circumstances whereby the income tax can also be levied and simultaneously this property can also be attached as Benami property. If the facts are like that, then law permits so. Now, how it can happen? That we will discuss when we take up the practical case studies, but the law permits. Second thing is whether the other principles, other provisions of law, they are washed. For example, Indian Evidence Act, section 91 and 92, which says the documentary evidence of a transaction of effect shall have precedence over the oral evidence. So whether here, suppose under PBPT law, some statement has been recorded whereby the statement says that say Mr. X is the owner of the property, statement recorded by PBPT officer. Whereas the documentary evidence is saying that Mr. Y is the registered owner and he is the owner, whole soul, he has the possession. Revenue records also shows his name. Usage also is shown by the documentary evidences by him only. So what will happen? Whether we will forget about that section 91 and 92 of Indian Evidence Act because of this section 67, which I read before you. This is that section 67. What is the position in this regard? Here I think the officers have made them confused unnecessarily, because this is saying when there is anything inconsistent in any other law. So inconsistence means there should be anything contrary to section 91 and 92 under this PPPT Act, which is not there. So nowhere it has been said we will disregard the provisions of Indian Companies Act, we will disregard the provisions of Indian Evidence Act. Nowhere it has been mentioned under PPPT law. Meaning thereby, all these legislations shall have their respective effect under the overall legal system of the country, unless any one of them is specifically erased by under PPPT Act, because they are all offsprings of Constitution and they have to give respect to each of them. So if Company Act allow creation of legal structures through companies, then PPPT Act cannot erase it. Prosecution. There is going to be lot of human crime on prosecution. The first question is that prosecution can be initiated at what stage? Prosecution of whose persons? That I have shown you, 3 persons are covered there. At what stage? I mean, once that all these things are decided by Supreme Court, or even at the initial stage? What stage? So board has given a clarification that initiating officer is required to process the case for prosecution of the persons concerned under section 353 and 54 at any stage depending upon the facts of the case. So law is like that. If the IO has sufficient information before him that such and such offense has been done and he has material in possession to support it, then he can launch the prosecution simultaneously. That is what the provisions of law is. Practically what they are doing? Practically they are waiting for the order of the tribunal or order of the adjudicating authority. So if appeal has been filed, they are waiting of the result of appeal from the tribunal. If the appeal has not been filed, then immediately after the adjudicating authority, they are filing the prosecution. Now I have heard in some cases, they are simultaneously launching the prosecution simultaneously with the proceedings initiated under section 24. The moment provisional attachment order is passed, prosecution complaint is also being initiated. Friends, while making representation, certain points or principles I have compiled for you for discussion that you kindly keep in mind, because the fabric under Benami law is totally different from the fabric of income tax law. Burden of proof concept is totally different, because according to my little understanding, in any litigation, the the game changer is, or I would say the pivotal point is burden of proof. Whose burden is what under the law? When this burden has been said to be discharged, when not, in what manner yes, in what manner no. If I am aware about this fundamental principle, I can effectively handle the litigation within the four corners of law. That is how I believe. So burden of law concept is totally different under income tax law and under Benami law. Because under Benami law, they are applying the same principle as they apply under income tax law, the entire burden is of the SSE. It is not that. Even after introduction of PBPT Act, tribunal says in one judgment, which I argued vociferously before the tribunal, now published as Pamela Bhardwaj, name of the judgment, and Ramneet Singh Kochar versus IU. It is a published judgment, again available on the site of the IU tribunal. You can note down the name Pamela Bhardwaj. It talks about in detail about the concept of burden of proof. It says the burden under the law is upon the IO, taking clue from the judgments of Honorable Supreme Court in P. Lilavati, Ammal Mangathai, and also few other judgments which were already available with the Bhim Singh versus Khan Singh, very various judgments available of the Supreme Court on this particular final principle. Then, sir, also keep in mind the principles of natural justice, rules of evidence is to apply, like Indian Evidence Act, opportunity of cross-examination wherever the law permits, wherever the facts demand. I mean, it is also mandatory. All provisions of CPC, Indian Evidence Act, Indian Penal Code, Criminal Procedure Code, or any other act to be applied, so long as these are not inconsistent with the provisions of these things. Four things kindly keep in mind while making any representation. Then, though Section 81, 82, and 94 of Indian Trust Act have been repealed in 1988, but the provisions with regard to fiduciary under Indian Trust Act, these have been still retained. So there, meaning thereby, this exception which has been given under Section 29A, that is a person standing in fiduciary capacity for the benefit of another person towards whom the stand in such capacity, and includes a trustee or a participant and any other person as may be notified by the central government. This exception is really a very, very meaningful exception. The law recognizes it, and this is well retained, still well retained. Now, fiduciary capacity can be explicit or implicit as well. I mean, there could be circumstances where the fiduciary capacity is explicit, for example, partners, directors. But there could be certain circumstances where the circumstances are such that the law would recognize them as fiduciary capacity. So, under that circumstances, also we have to claim this benefit at the right stage, giving the circumstances and the evidences in this regard. This has been so, and the benefit can be taken from the judgment of Supreme Court in the case of Marcel Martin versus M. Printer, where they have said that even if fiduciary capacity is not explicit, but it could be implicit also. And then you can read Section 88 of Indian Trust Act, which has not been repealed. And this judgment of P.V. Sankrakrup versus Leelavati. Now, with regard to filing of appeal, friends, this is very, very important because, as I said, now up to the level of adjudicating authority, there are chances that there will not be judicious application of mind. The judicious application of mind will start from the tribunal stage only. So this institution assumes very, very great significance. And I have got very good release from the tribunal in last couple of months before retirement of Justice Honorable Justice Manmohan Singh. And few judgments are available on the site also. Around 10 judgments only could be delivered by him, and 5-6 judgments were argued by me there. And some of these judgments are laying down final principles with regard to burden of proof and bona fide ownership concepts, etc. Now, the important points which I wanted to discuss before you was that here appeal is to be filed within 45 days as per law from the date of the order, but practically they are allowing from the date of receipt of the order, thankfully. But the law says from the date of the order. Then appeal is to be heard by division bench. Then no time limit to pass the order by the tribunal. Then CAs are authorized to appear before the tribunal. Those CAs are authorized, but I strongly recommend that tribunal appeals here are, I mean, they are based upon the final principles of all these laws which I have mentioned, Indian, right from Indian Evidence Act to CPC to CRPC to Indian Trust Act, Indian Succession Act, etc., etc. So here the appeals are not to be filed in a crisp manner as is filed before the appellate tribunal, that only 4 or 5 grounds are taken one page and that's all. No, here the appeals are to be filed exhaustively, where complete pleadings and grounds have to be taken along with the requisite facts and evidences. So, I mean, the entire exercise is to be done at the very, very beginning only. No casual working will help you get relief here in the tribunal. No crisp working. Working has to be detailed, thorough, meticulous, supported with all the facts and evidences and complete pleadings. Sometimes we think of going for writs, but now the high courts are not entertaining the writ in each and every case. So therefore, to ensure whether this is a case fit for filing of writ or not, at least these things should be ensured. that the case is such where it can be shown that palpable injustice has been done. There is a total go by to the procedures. There is a total perversity in the actions of the orders. We have to show it on the face of it. Gross violations of principle of natural justice. Actions and orders apparently filled with malified intentions and approach. And actions and orders are patently arbitrary. Where detailed finding of fact is not required. Where the things are that even if these facts or allegations are accepted, the action which is being taken is not warranted under the law. Where it can be shown apparently, I think then it is a fit case for writ jurisdiction. Otherwise, high courts are not entertaining. They say, okay, you go by the procedures. Rather, sometimes while sending back the matter to the lower authorities, what they give is they write few extra lines also. If these kinds of properties are not Benami, then what else is Benami? I mean, etc., etc. I mean, there are serious allegations. The authority should go through and then decide. So, I mean, we must think twice before knocking at the doors of the High Court. So, friends, I think as far as this practical aspects is concerned, we can bring quietus for the time being, because we have with us two other topics also, and let's see what all we can cover, because I had also requested Kinjal Bhai to take up some of the issues which have been sent from the audience, so that whatever is left, whatever more you would like to discuss, that also we can cover up in our today's deliberation. So what I will do for the timing is I will take up a few things about the anti-money laundering law, and briefly I will touch upon the Black Money Act, and then Kinjal Saab can take up the topics with regard to I mean the questions which will be there in the hands of Mr. Kinjal Shah.
Yes, right, sir.
Now my PMLA PPT is visible.
Uh, yes, visible.
All right. So friends, before I begin with this my journey on anti-money laundering law, I just want to ask you, what according to you is money laundering? Any guess? Any idea? What according to you is money laundering? Somebody would say that, sir, conversion of black to white is money laundering, but that is tax evasion. So what else is there in money laundering? Symbolically speaking, when a person converts from red to white, then it can be said to be akin to money laundering. Now, what is red here, and what is the difference between black and red? Now, black can denote only tax evaded money transaction. Red denotes something where criminal element is involved, criminality is involved, crime is involved, any offense is involved. Then it becomes red. So conversion of red to white, meaning thereby something which is derived from commission of a crime, and then showing it as if it is not from crime but from some legit activities, is money laundering. Washing the color. So currency has its no color, in fact. It could be digital currency also. So where the color would lie? In the usage, the portrayal, the intentions, the way it is shown, etc., etc. So I will touch upon only few aspects with regard to money laundering. I will not go deeper into the technicalities, though these slides are quite exhaustive, but I will not go deeper. I will touch upon the basic fundamentals, and I will touch upon those areas where the chartered accountants can play their role about the money laundering. Now, firstly, friends, let's learn one thing very quickly, that the spectrum of this law is very, very wide. Canvas is very wide, and that is why you would have noticed that under the new law, under this lockdown, only one department was quite active. And what was that department? Enforcement Directorate. Apart from health workers and security and eateries, Apart from these three, only one department was very active, that was Enforcement Directorate. So that means it shows the intention of the government to implement this law vociferously, strongly. Now these chimpanzees were attached by the Enforcement Directorate. Now anybody, I also thought, yeah, how chimpanzees and Enforcement Directorate, how PMLA. So that is why I was saying that the connect is so wide, net is so wide. Now, these chimpanzees were attached because these chimpanzees were procured by a person by making violation of Wildlife Protection Act and some forgery, which was punishable under IPC. So it became scheduled offense. So it was crime. So these were proceeds of crime, and proceeds of crime are liable for attachment by the Enforcement Directorate. That is why they were attached. Thankfully, they were handed over back to the zoo authorities. That is a different thing. But these were attached in that fashion. Now you must have read that recent Modi's Benami law has companies running for cover. So this law is being applied on the new, the listed companies also. Then this slide I wanted to discuss with you. CBI ED action may now follow IT default probes. So coordinated action is being done with the help of data analytics. So since coordinated action is going to take place by the investigation agencies, there will be multiple application of different laws. And since different laws will be attracted, it is essential to have basic awareness of these laws so that requisite consultancy could be given accordingly. Now, this I have already explained that how it works, offense of money laundering, that there is one illegal or dirty money which is converted into legitimate white money. How? By showing it from legitimate activities. Then which legislation governs money laundering? The Prevention of Money Laundering Act prohibits and penalizes the money laundering activities in India. So it is PMLA, Prevention of Money Laundering Act 2002, which is the governing legislation. Then what are the agencies? Enforcement Directorate, who the executive functions under the act, like search and seizure, provisional attachment, arrest, initiate prosecution, etc. These are performed by the authorized officers under the act. Then we have adjudicating authority. As I said, now this authority sits in Jeevandeep Building, Parliament Street, New Delhi, and presently headed solely by Shri Vinodanand Jhaji, who was earlier Chief Commissioner in Bombay, in Bombay. So 1983 batch IRS officer. He is member finance, and he is now heading the adjudicating authority, who shall be dealing the orders which will be passed by the Enforcement Directorate. Then again, appellate tribunal, same appellate tribunal about which I mentioned a few minutes back. So appeal is to be filed within period of 45 days here also. And then after the appellate tribunal, then we have High Court and Supreme Court. And then here we have special court, Court of Sessions. So this Court of Sessions, again, whatever prosecution complaints are filed, those are filed by the special court. And one thing more, not only prosecution complaints under scheduled offense, but also under PMLA. Both are done simultaneously by the special court. So sometimes you must have heard that the experience before the ED is really very, very vexatious and very troublesome. Now, it is also because of the reasons that the web of action is created the moment any action is done under ED. And I have tried to portray the illustrative picture how the person gets disturbed because of the actions from various directions. Now, as you would see from the slide, I have bifurcated into two parts. Firstly, investigation or search by the basic agency, that is income tax or police or CBI, narcotics, etc. And the other part is investigation by the Enforcement Directorate. So both happen simultaneously. So say suppose action is done by CBI, so some complaint will be filed for scheduled offense, charge sheet will be filed in the Judicial Court of Sessions, and which will be pending in the special court then because of its attachment with the PMLA proceedings. On the other end, with regard to the same offense, if the investigation is launched by the Enforcement Directorate, then it will also do two things simultaneously. It can file complaint to the court, that is Court of Sessions, which ultimately be combined in the same special court where the scheduled offense is being tried. And then provisional attachment order will also be passed with regard to the property which are allegedly involved in the offense of money laundering. So with regard to this third action, with which we as a chartered accountant will be mostly concerned, it will be provisional attachment order will be thereafter made subject matter of proceeding before the adjudging authority, which will again be subject matter of confirmation, and which will be again a matter before the appellate tribunal and then High Court and Supreme Court. On the other hand, this investigation, it will reach to the special court. The special court will pronounce whether there is a conviction or not. If there is a conviction, then again it will also pronounce about the confiscation of the property which is already attached. So that is how simultaneously many actions start. So as I said, we will be focusing today with respect to the attachment part only. That is the third action, that is provisional attachment order by the Enforcement Directorate. Now, first of all, let us understand the formal definition also of offense of money laundering. Now, PMLA defines under Section 3 money laundering as whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming as untainted property, shall be guilty of offense of money laundering. So, how a person will be guilty of offense of money laundering has been defined under Section 3. Now, this definition has many loose ends or controversial points, which create different kind of interpretations, and that is how this section is prone to great misuse by the authorities. Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime. So meaning thereby there would be a crime, there would be earning of proceeds of crime, that proceeds of crime, say first of all it is earned, then it is transferred, then it is possessed, then acquired by somebody. So all these things will fall in the category of offense of money laundering. And projecting or claiming as untainted. Now kindly see the word used here is and. So meaning thereby there should be and. So you have to not only, a person has not only to earn the proceeds of crime, but it has to project it as untainted property. Only then offense of money laundering can be said to have taken place. Now I have put this word and in red color, and there is a reason behind it, because of the explanation there is an attempt to change the concept of this word and. Now kindly see, for the removal of doubts, it is hereby said that a person shall be guilty of offense of money laundering. A person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more process, one of the following processes or activities connected with the proceeds of crime, namely concealment or possession or acquisition or use. Kindly see the word or has been used. This explanation has been added with effect from 1st August 2019. Or projecting as untainted. So kindly see in the previous substantive part, there is a user of the word and. Here the word is used as or. So what is the, message of the legislature? I am not able to decipher, because if you use the word or before the word projecting, meaning thereby the moment a person earns some proceeds of crime, even if it is not showing it as untainted, he has committed the offense of money laundering. How it is possible? Suppose a person has done theft. Now this stolen money, he is not mixing up with the clean money. He is not even portraying it as untainted. So mere doing the crime, mere doing the theft itself, whether it will push him into the deep well of money laundering. This kind of explanation is, I would say, enabling few people to make such kind of interpretation. But according to my understanding, it will shake the very concept of the money laundering. In that case, there will be effect of double jeopardy, that the person will be punishable for theft under IPC, etc., before the court of sessions, and for that very offense he will be also liable for money laundering, which is not possible, I think. So this kind of interpretation is being wrongly done. Then what is proceeds of crime? Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. So proceeds of crime, simple meaning is that something which is earned from any criminal activity. Now, which criminal activity? In fact, there is a schedule to it. One schedule is there. And so any criminal activity which is find part in that schedule is called a scheduled offense. So any earning done from scheduled offense, commission of scheduled offense, will be proceeds of crime. Now the next question which arises here is, suppose that that very property is not available. So whether any other property can be said to be property from criminal activity. I mean, because of the user of the word value of any such property. Now the answer is no, and which I will discuss little later how. Now scheduled offense, as I shared with you, scheduled offenses are the offenses as prescribed in the schedule to the PMLA, which is divided in three parts: Part A, Part B, and Part C. The scheduled offense is the genesis of the offense of money laundering, as there cannot be any offense of money laundering unless and until an offense provided in the schedule of the PMLA has been first committed. So this law is piggybacking law. So piggybacking law means it sits on the back of some other law, that is some other offense. So there has to be first of all offense under some other law which is given in the schedule, and only then offense of money laundering can be said to have taken place. There are three stages as I discussed with you. Stage number one is commission of scheduled offense. Stage number two is generation of proceeds of crime. And stage number three would be commission of money laundering by placement, layering, or integration. Only then process of money laundering can be said to have been completed. So three stages in the process of money laundering. Then few important things which I have picked up for discussion today is that there are few areas where there is a difference in the law in the books and law in practice. So I'll touch upon one or two areas only today. Before that, I hope it is within your knowledge that Interministerial Coordination Committee has been constituted under Section 72A, where all these agencies, all these investigation agencies can work together. Now, as I said, proceeds of crime, whether any other property can also be covered for the purpose of attachment? My answer is no. And the reasoning is given here in this slide. Kindly see, this whole definition can be divided into two parts. It talks about value of any such property. Where the property is held outside India, then it talks about property equivalent in value. So meaning thereby the intention of the legislation is clear that only with regard to outside properties only, any other property it is talking about. Here it is talking about value of any such property, meaning thereby such property whose value becomes whatever in course of time. Suppose a person did theft of shares. Now, after say he sold the shares and say it was of rupees 10 lakh rupees. Then that investment was say made in a plot of land, and that plot of land was increased to say rupees 50 lakhs. Then that 50 lakh rupees becomes the value of any such property, meaning thereby the 10 lakh becomes 50 lakhs. So only that. Suppose now that 50 lakh plot also he sells, and whatever 50 lakh rupees comes, he goes to casino and loses the entire amount of rupees 50 lakhs. So in that case, if he has got any other property unconnected with this, say suppose he has another plot of land which was gifted to him by his grandfather, whether that can be covered in this first situation, my answer is no, not at all. And I have been saying it for last few years, but nobody was listening. But thankfully, one judgment has come in my favor, and the name of the judgment is Seema Garg from Honorable Punjab Indian High Court, where the same reasoning has been given, which I have been arguing for 2 years. It is dated 6th March 2020, Seema Garg, and then Satyam Computers from Andhra Pradesh High Court. These two judgments are directly on this point, that no other property can be said to be property derived from proceeds of crime. Other important controversial area is about burden of proof. Now you must have heard about this, that the proceedings initiated by the Enforcement Directorate are quite harsh. And one of the reasons for the proceedings being quite harsh is here the fundamental concept of a under of the constitution of the person being innocent unless proved guilty has been changed, because it says a person will be presumed to be guilty unless rebutted by him. So burden to prove innocent will be upon the person, that I am innocent, that he is innocent. He will have to prove himself. That is what some people are saying section 24 of this PMLA says. It is true, but partly only, not fully. Kindly see what 24 says. It says in any proceeding related to proceeds of crime under this act, in case of person charged with the offense of money laundering, the authority or the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. So the presumption, power of presumption has been given only with respect to the proceeds of crime involved in money laundering. But as I said, there are 3 stages. Stage number 1 is there should be commission of crime, the running of proceeds. Then these proceeds are proceeds involved in money laundering. So as far as first 2 stages are there, no power of presumption has been given there. So it has to be charged. Person has to be first of all charged. So burden to prove is upon the prosecution to show that this person is charged. So he has to be firstly charged, not that he is merely accused. So he has to be charged. And then there has to be enough evidences to show that he has earned so much proceeds of crime from that proceeds. Only then the presumption about the third stage would come. Now, friends, the most, again, the difficult part here is that the ED has been given sufficient powers to make attachment of the properties which are found to be involved in money laundering. So it can record reason to believe and it can make attachment. Now, with regard to attachment here, many such things are happening which is causing trouble to many people who are either unconnected or they are not that much connected as much property is being attached because of these interpretation issues which I shared before you. Now, with regard to attachment only, I would discuss with you few important things here so that with the help of this case study so that you become aware about that how the attachment things are working, how they are causing trouble, and how a chartered accountant can perform his role in defending his client in accordance with law. Now, this case study belongs to Rajasthan only, where the distillery unit was set up, and it was alleged by the pollution control department that it has done violation of Water Pollution Control Act by discharging more water into the river than it was allowed. So suppose it was allowed to discharge 50,000 kl of water, but it has discharged 75,000 kl of water. So this 25,000 kl of water which is excess discharge, it is violation of Water Pollution Control Act. And the water quality was also not in accordance with the norms, etc., etc. These kind of allegations were made. But subsequently, repair was done of the treatment plant, and after doing the requisite repairs, no further action was done by the PCB, Pollution Control Board. But in the meantime, Enforcement Directorate swung into action, and it gave show cause notice of making attachment of the factory. So everybody was shell shocked that how it is possible with regard to Water Pollution Control Act, how ED comes into action. So the case of the ED was something like that, that since you have done violation of Water Pollution Control Act, okay, which is a scheduled offense, okay, so you have discharged more water into the river, all right, but how, what is the money here laundered, etc., etc. So the case was set up like this, that by discharging more water shows that you have done more production than the permissible capacity. So excess production is illegal because it is after making violation of Water Pollution Act. So this excess production has resulted into extra profit. This extra profit from earned from this illegal activity has been ultimately, because it has been earned, sold extra sales means extra profit, and this extra profit is invested into factory only. So therefore factory building is being attached. So that is how the even unconnected things can be connected here under Enforcement Directorate. So we have to be very, very careful. So similarly here in the case of Bitcoin scam which happened in the country, whereby one company which had floated Bitcoin schemes was roped into by the investigation agencies and then finally by the Enforcement Directorate. So one of the investors who was very close to the management, he also made investment in Bitcoin. So since he was also roped into investigation, allegations were filed against him. So ultimately his Bitcoins, so attachment was done of his properties also. So since they could not find the Bitcoins, the agency made attachment of the FDRs of that very person. Only because he was very close to the management, it was perceived that he has helped in abating this crime. So therefore, his properties also came under the radar of attachment. Now, friends, role of chartered accountants and tax lawyers in handling notices and attachment orders issued by the ED. As I shared with you, the most of the cases which come before ED are those where the attachment is to be made. And attachment is to be made of the property which is derived from proceeds of crime. Now, what is the property exactly which is derived from proceeds of crime? It is a big question in itself. The chartered accountants can play a greater role in understanding the financial transactions which the seasoned criminal lawyers and the specialized criminal or civil side lawyers, they are not able to do it themselves. So what happens, neither the AD understands the trail of the money, the financial structuring, nor these lawyers understand. So ultimately a lot of experiment work is done and grave injustice is also done in many cases. So excess killing is done in many cases. I will give you an example, a case study, which is now most frequent example happening in our country, which is with regard to the defaults done by the borrowers in the case of banks. So, if a loan becomes NPA or any default is done, then in most of the cases, some FIRs, etc., have been filed by the CBI, by the banker with the CBI, that this loan, so and so loan has become default, has become NPA, and this loan was actually obtained by fraudulent means, etc., etc. So CBI comes into action. Immediately thereafter, ED comes into action. Suppose ED comes into action, so the allegation would be, suppose a corporate had taken a loan of rupees 1,000 crore. So ED's charge would be this entire amount of rupees 1,000 crore would be proceeds of crime. So therefore, proceeds of crime, this is liable for attachment. Now, since it is liable for attachment, so ED would try to find out the trail. Now, in that process, it will make attachment of various people with whosoever has dealt with the company. So suppose that borrower, defaulter borrower, he has, say, used that money in acquiring some properties, in making payment to other persons. So wherever this payment has gone, the trail is followed and the attachments are done. So if the transaction is of big size, this entire financial trail, it becomes very, very difficult to understand and explain. So there comes the role of the chartered accountant, at least in explaining, in understanding that financial structuring example and portraying it correctly as per correct facts and law, and presenting it to the court with the help of the lawyer, so that this requisite defense mechanism as per law is created and no excess killing is done, no injustice is done with the clients. Now, to give you an example, the chartered accountant can play a role in identifying the source of the attached property and differentiating it with the alleged POC. Then it can identify loan utilization in the attached property. Then it can help in calculation of the correct value of any alleged POC. Then it can also do valuation of the property attached and comparison with the alleged POC. Then proper financial accounting analysis can be done. Then preparation of money trail for the attached properties to demarcate the source of the fund can be done. So friends, that is with regard to PMLA. Unless some more questions are asked, I think that will be enough for the time being. And I'm sure many questions would be there with Kinjal Saab in this regard. And we can take up whatever is left, we can take up therein. Now, before we take up this question answers, I will briefly touch upon the, very briefly in 5 minutes, the final concept about the Black Money Act, the law with regard to curbing the menace of black money in the country with respect to foreign jurisdictions only. So there is some misunderstanding. So therefore, I would touch upon in 5 minutes or so the important areas which we should know about the black money. Friends, in fact, with regard to black money, the first confusion which arises in our mind is that it is talking about the black money happening in the country, being generated in the country, circulating in the country. No, it is not like that. If you read the full name of the act, kindly see, it talks about black money, within brackets, undisclosed foreign income and assets and imposition of tax act. So it is first of all talking about undisclosed foreign income and asset and imposition of tax thereupon only, not on anything else. So with regard to black money, we have to keep in mind that this BMA, this act is talking about this only. With regard to black money, otherwise, in the country, domestically, there are other laws like income tax law, like PBPT, like PMLA. like Fugitive Economic Offenders Act, etc., FEMA, etc., etc. So the whole objective of this law is to detect undisclosed foreign assets and income earned from undisclosed foreign sources by all persons residents in India, and taxing such income and penalizing and prosecuting the offenders. So it is, kindly see from this objective, it should be clear that it is talking about the detecting the undisclosed foreign asset only, foreign asset and income only, earned from undisclosed foreign sources by all persons. So it is not talking about domestic sources. It is focusing on undisclosed foreign sources and talking about foreign asset only. If the asset is located in India, it has no jurisdiction. If the income is earned outside India and oblique or asset is located in India, only then this law can be applied. What is its enforcement agency? Enforcement agency is same, Income Tax Act, but now they are Income Tax Department, but they are carving out a special cell under black money also, I am told. So far, the officers of the investigation wing have been given jurisdiction to make assessment under black money, that is Section 10 of Black Money Act. But very soon they are coming out with a separate cell, maybe on the lines of BPU, they are carving out a cell to deal with BMA cases. Now, how the liability and charge under this law takes place? It says, Section 3 clearly says, there shall be charge on every assessee for every assessment year, commencing on or after the first day of April 2016, subject to the provisions of this Act, a tax in respect of his total undisclosed foreign income and asset of the previous year, at the rate of 30% of such undisclosed income and asset. So it is taxing a tax in respect of his total undisclosed foreign income and asset of the previous year at the rate of 30%. So there has to be total undisclosed foreign income and asset. What is that? Not let us try to understand. Proviso says an undisclosed asset located outside India shall be charged to tax on its value in the previous year in which such asset comes to the notice of the assessing officer. So it is on the value. I mean, this proviso saying it should be on its value in the previous year in which the asset comes to the notice. So whenever the asset might have been acquired, but because of this proviso, in the year in which it comes to the notice of the assessing officer, in that value in that year it will be assessed. Now, meaning of value of undisclosed asset means the fair market value of an asset, including financial interest in any entity, determined in such manner as may be prescribed. So any asset located outside India, this undisclosed asset located outside India means an asset located outside India held by the assessee in his name, on respect of which he is a beneficial owner, and he has no explanation about the source of investment in such asset, or the explanation given by him is, in the opinion of the assessing officer, unsatisfactory. So meaning thereby undisclosed foreign asset should be there, which should be located outside India, either held by assessee or in respect of which he is a beneficial owner. These lines are very important. So with respect to Benami things happening outside India, this law is taking control. So this law is taking control of the foreign assets and income and anything Benami happening outside India. So it is two into one. Benami as well as undisclosed. Both are being taken. So it is a combination of income tax law and Benami law with respect to the foreign earned income and assets located outside India. You can say in summary like this. Then, what is the total of foreign income and asset? Undisclosed foreign income and asset means the total amount of undisclosed income of an assessee from a source located outside India and the value of any undisclosed asset located outside India referred to in Section 4 and computed in the manner laid down in Section 5. Now, this definition of assessee is also very important. Assessee means a person being a resident other than ordinary resident in India within the meaning of Section 6 of Section 6 of Income Tax Act, by whom tax in respect of undisclosed foreign income and asset or any other sum is payable under this act, and includes every assessee who is deemed to be an assessee in default under this act. This is in red. So kindly see, this is prior to amendment, right? Now amendment has been made to include one more category here, and that category would be clear now by if we read this. Being a person resident in India within the meaning of section 6, which is coming from the previous definition. Now being a non-resident, that the person is now a non-resident. Being a person non-resident in the previous year in which the action is taken, who was resident in India either in the previous year to which the income referred to in section 4 relates, or in the previous year in which such undisclosed asset located outside India was acquired. So it is, this amendment has been done to rope in a situation that if even if the person has become subsequently non-resident, but if he was resident when the asset was acquired by him, so if that means that he was resident, so its taxes with regard to the acquisition of such asset, if it is from undisclosed sources, should have been paid in the country, being resident, not paid. So for that purpose, he continues to be resident even if he is non-resident today. That is what this amendment is suggesting. Now we will read section 4 and 5 only for the time being today. Now section 4 says talks about scope of total undisclosed foreign income and asset. It says it will be aggregate of the following three amounts. A, income from a source located outside India, not disclosed in the return of income furnished within the time specified in explanation 2 to subsection 1 or 4 or 5 of section 139 of the Income Tax Act. Or if no return is filed in case mentioned above at point A, and the value of any undisclosed located outside India. So three amounts are included here. Number one, income from a source located outside India, no disclosed in the return, or if the return is filed, and if no return is filed, then also, and the value of any disclosed asset located outside India. So income undisclosed or undisclosed asset, both combined together becomes the total amount available for being charged under PMA. Now there are certain specific exclusions from the definition of undisclosed income. Say suppose any variation is made in the assessment, no expenditure will be allowed, any adjustment is made under section 92C. So all those things, I mean, they will not be covered here. So on the one hand, there are some provisions which are beneficial, some provisions which will be harsh. Now these are harsh provisions when they are excluding the benefit or deduction. Then there are certain permanent exclusion under the Income Tax Act. Total income included in the total undisclosed foreign income and asset under BMA shall not form part of total income under the Income Tax Act. So meaning thereby it is simply saying that if something which is assessed under the Income Tax Act, that will not be assessed under BMA. Suppose which has already been assessed. Because in future, there is no problem. This is mainly given to, to protect the transactions which were done prior to 2015 or 1/4/2016. Because now onwards, after 1/4/2016, there is a total demarcation. Anything undisclosed with regard to foreign sources or assets, that will be assessed under BMA. Everything else under Income Tax Act. So this overlapping will not be done now. Then how the computation will be done? What will be the things which will be allowed or disallowed? In undisclosed assets of any previous year of SSC, no deduction shall be given in respect of any loss. Then any income which has been assessed to tax for any assessment year under the Income Tax Act prior to assessment year with this under this act, or which is assessable or has been assessed to tax for any assessment year under this act, shall be reduced from the value of undisclosed asset located outside India if the SSC furnishes evidences to the satisfaction of the assessing officer. So first provision is saying that no deduction will be given. Second provision is saying that if something is already assessed, then that shall be reduced. So no overlapping. Then proviso 2, the subsection 2 is also important, which says amount of deduction referred to in clause 2 of subsection 1 in case of an immovable property shall be the amount which bears to the value of the asset as on first day of financial year in which it came to the notice of the assessing SSC assessed foreign income. Meaning thereby, suppose the asset whose value has increased and some portion is disclosed, some portion is undisclosed. So proportionately deduction shall be given. So that one illustration has been given to explain the same thing. So friends, I think the basic fundamental I have explained how BMA is going to work, that anything which is related to the foreign undisclosed transaction shall be accessible under BMA. So the message which you can pick up now today is that whatever returns are being filed, now there are applicable columns. A financial asset column has been added, schedule has been added with regard to the disclosure of the financial asset located outside India. So proper disclosure should be made to avoid any hassle or ill consequences under this law. For example, any bank account is held abroad, any asset is held abroad, anything which has of any monetary value, maybe some benefit in the trust, etc. All those things should be properly disclosed in the return to avoid any adverse action under the law. So there are a lot to be discussed under BMA. Lot many things are happening, but I think today, since all three topics have been confined, we can, if required, we can make a specific emphasis with taking up each topic separately as and when WIRC will invite, if considered necessary. So for the time being, friends, I think that is enough for the day, and this is already 12. So good time is there with us. I will request Kinjal Saab to take up if any issues are left or if he has compiled any issues, so that for the benefit of the members we can dwell upon all those issues.
Sir, one immediate one or two questions which has come up is that now the jewelry industry and the real estate stock, I mean, real estate brokers are also covered under the PMLA. So can you just throw some light on what they are supposed to do and what the law, I mean, ask them to report, I mean, reportable transactions, and what is the regulatory requirement for them?
I think you can take up all these questions. There are many other questions. This is also
Right.
another controversial
Yes.
area. Let us begin with fundamentals first of all, and then we can
Okay.
take up one by one all together.
Okay.
Because the issues which you were discussing with me yesterday,
Correct.
and many questions have come up in the question answers also. So either you can take up first of all the fundamental questions which you were discussing, and then
Right.
we can take up this thing also.
Okay.
Yes, sir.
Just a moment.
First we take up Benami,
Okay.
and then PMLA, and then black money. In that sequence, if
Right.
you can take up.
Correct. Sir, one of the question is that there is a age-old customary practice in India of holding the asset in somebody else's name. So whether those old transactions which are done before the enactment of the new law in 2016 would also, I mean, be covered under the new law?
I think very good question has been asked, and this is the most controversial question of the day being raised in the entire country.
Mhm.
Look, the way law has been drafted is very unique. Firstly, if you hear, you would have heard Mr. Arun Jaitley, late Mr. Arun Jaitley, while speaking on the floor of the House, he said, "We did not want to give benefit of immunity to the people who have done Benami transactions in last 28 years, meaning thereby between 1988 to 2016. Though law does not specifically narrate itself to be retrospective, but certain provisions have been created in such a manner, or certain omissions have been done in such a manner that it is trying to create a retrospective effect. To begin with, section 1 subsection 3, which says that this all the sections shall be deemed to have come into effect from the day one, from the commencement of this act. So that is also creating a problem. Then the wording of section 29 bracket A, which says if the property is transferred or held. So if it is transferred, if it is retrospective, if it is prospective, so let us presume transfer should be done after 1/11/2016. Only then this law can be covered. But even if it is held to be prospective, the held should be today. Now, if the held should be today, all right, but held since when? That is not clarified. So the period of holding can be even prior to 2016, anytime 2016. So if the transactions were done Benami earlier and they continue to be held today, then as per the understanding given by the initiating officer, these can be covered. So many judgments, 3 judgments are already available of high courts. One judgment is saying yes, it is retrospective, even prior transactions can be covered. Rajasthan High Court and Calcutta High Court are saying no, it cannot be covered, only it can cover prospective transactions only. SLP against the Calcutta High Court judgment has been filed in the Supreme Court, Ganesh Dealcom, and the Supreme Court has stayed the operation of that judgment, so which was saying it is prospective. So as on date, the initiating officers are taking action. I mean, in the entire spectrum, whether the property is held today, uh, and irrespective of the fact whether it was held earlier or subsequent, whenever it is held today, actions are being taken. Rather, in some cases, they have also taken action where the property has already been transferred, but still actions have been taken because of operation of section 6 bracket 1, which says, because somebody has asked this question also, that whether U-turn is allowed under the law. So section 6.1 says no U-turn is allowed. Once Benami, always Benami. So this is a most controversial question. Let us see how it rests.
Okay, okay. But sir, what would happen if the asset had been acquired out of the legitimate source of income, though held in somebody else's name, or partially acquired by legitimate income and partially, from an undisclosed source? So, what would be the scenario in such case?
Very good question. Why I am saying good question? Because this is going to be another controversy. People would say कि सर हमने कुछ गलत इंटेंशन से नहीं किया सर, देखिए सारी टैक्स पेड मनी है. That is why I said, that is why I read section 60 and 67, because section 60 says this law is in addition to other laws. So whatever you have done in Income Tax Act is a different thing. If you have done Benami, it is Benami. So there could be simultaneously application, also singular application of the law also. Even if everything is hunky-dory under income tax law, but the transaction is Benami, it is Benami. And vice versa also. Anything is possible. Vice versa means, if tax evasion has taken place and Benami has also been done, so a person may be held liable for tax evasion also and for Benami also, depending upon the facts and circumstances.
Okay, okay. One more question is whether the Benamidar would also be liable for fine and prosecution.
Look, this law is very, very, very strange law. Suppose the definition of Benamidar itself shows that Benamidar means a person in whose name Benami property is held, and also includes a person who has lent his name. So mere name lending itself has been, made a reason to treat him as Benamidar and to face the consequences under Benami law. So whatever he may keep arguing कि सर मैंने तो खाली नाम दिया था, मेरा तो और कोई काम नहीं है ना, नाम क्यों दिया था, वो तो कहते हैं नाम भी मत दो गलत काम के लिए. So all these Benamidars who used to get scot free, they are going to be now hold up under this law.
Okay. And this definition of Benamidar, doesn't cover even the very near and dear, your relatives, which include your in-laws and your first cousins. So, what would be the scenario in such case?
Look. Only few exceptions have been given. Number one exception is, in fact, is to child and spouse. That to your own spouse, not somebody else's spouse. Own spouse and own child. Only these 2 exceptions are there. No other exceptions are there. Yes, there are few other exceptions like lineal ascendant and descendant, that is your mother, father, or your grandchildren, and your brother, sister. But there the embargo is that it should be from known sources and you should be co-owner. Right? Other than that, there are no exceptions at all. No jija sala, no cousin, nothing. If acquired in their name, साला का तो खास ट्रीटमेंट है साहब. साला को तो जितना मिसयूज हिंदुस्तान में किया है, तो कहते नहीं, नो, उसका तो हम मानेंगे ही नहीं बिल्कुल भी. So no exception.
Sir, another question is that if the transaction has been done by mistake and there was no malified intention of tax evasion or something, can it be reversed so as to avoid the unbearable consequences of the new law? In other words, whether there is any compounding or settlement provision?
That is what I was discussing a few minutes back, that there is a total embargo, very strange piece of legislation, that there is no scope of any U-turn. If Benami has been done, the law will take its own course, because section 6.1 says once Benami transaction has been done, then any transfer done thereafter shall be void. So meaning thereby, if you do correction, that is void. So very strange. They should have given scope for some settlement. even after taking some fine. Maybe you impose fine of 25%, but
Correct.
you give him the chance to do correction. If he's saying, okay, you, according to him, according to you, he's the beneficial owner, okay, I'm transferring his name.
Right.
This chance should be given. I don't know why then they are not giving.
Okay. So, I mean, in the same context, whether there is any protection for the bona fide buyer. I mean, what if his property status under
Yes.
the new law?
Yes. Yes.
Yeah,
Section
and
27.2 Section 27.2 gives protection to the bona fide buyer, and it is coupled with two conditions. Condition number one, that it should be paid for adequate consideration, and there should not have been any knowledge of Benami transaction. So these two conditions have to be brought on record.
okay.
Compliance of these two.
Sir, so another question is that in the same context is that while you are buying a property, what kind of due diligence should a buyer do to ensure that he doesn't end up getting caught on the wrong foot?
This is a very going to be a very, very tricky situation in times to come. Though government has not made out any robust mechanism, which they should, because unnecessarily people will feel harassed. But still, certain points which may come to my mind is that firstly, whenever you are going to buy a property, you see who is a registered owner. Sometimes it used to happen that we are dealing through property dealers. Property dealer says, I have done that deal. No, we are on the day of dealing only will come to know ki already this is he is not the owner. Owner is somebody else and registered owner is somebody else. So say Mr. Uh, Mr. X is dealing with me throughout, maybe with dealer through dealer or not. But on the date of registry, suddenly Mr. Y would appear, and he would say, no, no, हमने इनके नाम से Mr. Y के नाम से कराया हुआ था जी, तो इसलिए. So this itself on the face of it will show Benami. Then you have to probe further whether Mr. Y had the capacity to buy this land. So suppose Mr. X had financed him. This comes to your knowledge. And then it will be straight away Benami. I mean, and apparently you have knowledge because you are dealing with Mr. X. Registered owner is Mr. Y, who is of the person of say no financial means, of no level, financial standing. I mean, he is working as a peon or guard or driver, etc. So apparently you may fall in big trouble. So these are the basic fundamental things that while buying the property, you should get the copy of the sale deed. You should ask who is the owner, where from the funds have come. Because I am handling few such cases which are politically charged cases of the country today in the limelight and newspaper. There, this is the only defense we have. Sir, we have dealt with the genuine persons only, and genuine persons were the registered owner. If this is not the, because IU is asking, okay, you dealt with whom? So we are saying we do not dealt with any politically motivated person or something like that. We connected ourselves with the genuine persons, and these are the trail which was presented to us. So these are the things to be kept in mind.
Okay, right. Sir, I mean, considering that this law is too harsh, is there any grievance redressal mechanism available for people? I mean, for the so-called accused who can uh, approach the higher authorities?
As I said, that though they tried to provide a judicial grievance mechanism, but that is not working effectively because adjudicating authority, because first of all, the proceedings are done in a very crisp and fast manner. Say within 90 days, proceedings are over. So judicious application is not possible. Then adjudicating authority is highly overburdened. Then that adjudicating authority has also been jurisdiction has been transferred to competent authority. Now, how they will function, they are also not well trained. So appellate tribunal is also working not with full strength. So I think there is a lapse on this in this area. Our government should bring out a robust system, appellate system, as well as redressal mechanism system. Otherwise, many bona fide people might also suffer, and business would suffer. Projects will be held up unnecessarily. It will lead to the national wastage. That is not a
Right.
good.
Okay. Sir, another question is, I mean, there are a lot of provisional attachment orders which are being set aside at the appellate stage. Uh, so, what is your view? I mean, is the law found wanting on some of the provisions, or there is lack of application of mind at the assessing stage?
In fact, as I shared with you, that there was lack of clarity with regard to the implementation of this law, that what is the policy, what is the objective. So objective being not clear in the mind of the implementation agency, and not being the working not being fully quasi judicial or fully fair and judicious,
Hmm.
and there be less time to find out which property is really Benami and which not. And also the coupled with the fact that the agency is the same agency which is working under the income tax law. So I mean the working mechanism remains same, whereas the law is different, burden of proof is different. So all these factors put together, they bring out an order which is not necessarily in accordance with law. So since the order is not necessarily in accordance with law, the moment judicious application starts, they are not able to sustain themselves. That
Okay.
is a that.
Sir, another question is the agriculture land also covered under the Benami law?
Yes, I read before you the definition of property. I mean, this is widely and very widely written definition. Includes everything you can see and touch.
Okay.
Maybe something which you cannot even see and touch, like rights,
Uh,
like intangible things, if it has monetary value.
Correct. Sir, we have some more questions on the Benami law, but I will, for the time being, park it aside and go to the Black Money Act. Uh, the question is, what transactions or assets are exactly covered under the law, and whether any black money earned by a resident Indian or a non-resident Indian earned and accumulated in India and abroad is also covered, or
Under Black Money Act?
yes, yes, Black Money Act.
Yeah, under Black Money Act, as I shared with you, the focus is to tax the income which is earned by a resident from foreign sources or any asset acquired from undisclosed sources.
Mhm.
Those sources from which the asset has been acquired but held abroad, maybe for foreign or maybe from domestic. So any foreign asset, maybe from domestic sources or outside sources, or any income earned from outside sources. So
Okay.
foreign asset from any source and foreign income. These two are liable to be taxed while earned by a resident, not non-resident.
Okay.
Today he may be non-resident, but earning should be while being a resident, for
Okay.
which he was liable to pay income tax in India.
Sir, so in the same context, if a non-resident India is coming back to India and is going to become a resident, what kind of disclosure he should make so as to avoid any problem under this act?
Yes. Now he should disclose all the assets held by him abroad, because after the moment he becomes resident, then he becomes liable to be assessed under BMA. So therefore, whatever assets he is having, he should disclose in his return, because otherwise non-disclosure will take place.
Okay. This is especially the case in case of COVID, where there was a huge lockdown of almost three
Yes.
to 6 months, and many
Yes.
non-residents, while they got locked up here and now residents.
Though there are certain exclusions, that they were being not be treated as resident merely but for this reason. Some exclusions are there,
Hmm,
but in case they are being treated as resident, then they should be doubly sure and they should make full disclosure to
correct.
avoid, because the law will not be able to distinguish between the two, that you are staying here because of COVID or you are staying here because you wanted to stay there. You keep
Hmm,
on crying, we will listen to you. Better you make compliance of the law.
right. Uh, Sir, who is the implementation agency for Black Money Act, and do they have any powers of search and arrest?
Now, Black Money Act agency is something like that, that they that the income tax senior income tax authorities have been given the power to assign jurisdiction to the or to the for the assessment to the assessing officers. So what they are doing is that suppose there is additional commissioner under say investigation wing, so he can assign jurisdiction of being assessing officer to his subordinate, say for example his assistant commissioner or his deputy commissioner. So investigation wing officers are being mostly assigned the power to execute and implement this law, that make assessment under section 10. So they themselves do not have power to make power to do searches and surveys, but this power is being indirectly being used by them through the investigation wing officers of the unit to which whom they belong. So
Oh,
while carrying out search, so information regarding Benami, PMLA, Black Money Act, and Income Tax Act, all are being detected and being
hmm,
disseminated to the different places.
hmm.
It is happening like that.
Sir, another question is, what is the time limit under which old transactions which could be, I mean, taken up for scrutiny by the department, or whether it would cover only the new transaction?
Under what law?
Black Money Act.
Look, under Black Money Act, they are also covering up the old transactions because wherever the non-disclosure has taken place post 2012, right? So according to them, this is all covered under PMA. Now they are under ifs and buts. Their one thought is also suggesting that if the asset ceased to exist prior to 1/7/2015, then BMA cannot be invoked. But this is a matter of scope and discussion. As on date, the action is being taken, even if the asset was held previously but not disclosed after 2012, they are being hit under the Black Money Act.
Uh, so, sir, what would be the consequences in case the violation is found to have been done under the law?
There is a 60% tax, 30% penalty, making it 90%. So then prosecution under section 50, etc. So tax, penalty, and prosecution. So many
Oh,
prosecutions have already been filed. In some cases, even taxes have not been levied, but prosecution has been filed. For example, the
okay.
amount was small or assessment is yet to be done, but
Mm,
due to non-disclosure, a prosecution is being filed. So there is a prosecution. Two kinds of prosecution are there. One prosecution for the escapement of tax, non-payment of tax under Black Money Act, and other is for non-disclosure. The non-disclosure itself is an offense for which prosecution has been prescribed.
Sir, whether the gift received from a non-resident should also be disclosed under the Black Money Act? I mean, provided the gift has been received. I mean, what would the two scenario where the gift is received in foreign currency and gift is received in Indian currency?
Look, if the gift is received in India, it becomes an Indian asset. So you need to make disclosure under income tax return only appropriately, whatever consequences are there, right? If the gift amount is held abroad,
Mm,
say some foreign shares, say some bank account, say anything related which is lying outside, so then the requisite disclosure should be made in income tax return at relevant place so that the disclosure within the framework of BMA can also be said to have been complied with.
okay. So there is a specific question uh, where it says that the daughter who is a non-resident had gifted some money to the father for the medical treatment of mother abroad, and while this was not returned in disclosed in the return, but during the course the mother has expired. Now, what would be the consequences on father?
Sorry. Two, three things you have combined. Say
Yeah.
daughter has given an amount to father.
Correct. She is a non-resident. The daughter is non-resident. She has given
Okay.
some money to father in foreign currency for the medical treatment of her mother abroad. And
Mhm.
while this was not disclosed in the return of income by the father, but so what would be the consequences? And also, since it says that one of the parent has expired during the course of hearing, so
Hmm.
would there be any impact on that?
Look, they would like to because this foreign asset which was held, the foreign currency which was held, were never disclosed
Hmm.
in post 2012 return. So there will be attraction from the BMA authorities. But as I said, that if the asset itself did not exist prior to 1/11/2015, up before 1/7/2015, then the provisions of BMA itself should not apply. So it
Okay.
will depend upon these facts also. We need to dig out the facts and then accordingly appropriate answer can be given. But this principle can be applied and made use of.
Okay. Now I will take up some questions on anti-money laundering. One of
Yes.
the question is, what are the powers available to the enforcement directorate, and what are the right and obligation available to a person who is accused to be involved in the offense of money laundering?
If we say powers available, I think the widest powers have been given under the law to PMLA authorities.
Hmm.
Because power to make arrest, this itself contains, I mean, any other power available on earth you can envisage. How
Correct.
the powers are used, that is a different thing, but availability of powers is unfettered. Then power to make, of course, impound assets, record, power to search, these are all there. Power to impound records, power to seize assets, power to retain assets, all are there. You imagine it, and these are there.
Correct.
Then power to record statement under Section 50, calling them, doing investigation, everything is there.
Correct. And
As
they
far
are
as
quasi-judicial authorities as well.
yes, as far as and these proceedings are treated as judicial proceedings.
Judicial
As
proceedings.
far as rights are concerned, they are not defined anywhere.
Hmm.
So rights based upon the principles of natural justice, only they can be made applicable. Supreme Court is saying that there should be cameras installed in all police stations. So the underlying principle is that wherever the use of force is possible by the officer, it should be during the camera proceeding so that fairness should be maintained. But why did Honorable Supreme Court stop only up to police officers? I do not know. This has not been brought to your knowledge that the right verdict will be, I mean, the more appropriate verdict or the verdict will be complete only when it is also said police officer or any other authority which is using the force like a police officer, which has the authority to use the force like a police officer. They all should be done within the camera proceeding and in the presence of the lawyer. Now, investigation agency might say that presence of the lawyer may obstruct the obstruction proceedings,
Hmm.
investigation process. I can understand CBI or hardcore criminal. I can understand, but if the presence of lawyer is there, lawyer can sit at a distance place. Lawyer should not be allowed to speak unnecessarily. There should be camera. Then what is the problem in that? You can carry out your investigation, whatever you have to ask, but fairness, civic sense, I mean, all those things should be maintained by any authority whatsoever. And that is a mark of a civilized country. I mean, if it does not happen, then sooner or later, I mean, what is the difference between Taliban and our agency if all the parameters of humanity are forgotten? If torture not permitted under law is caused, I mean, that should not be allowed. Law should take its own course, but also in the manner as the law prescribes, not in any other manner.
Right. So broadly, I mean, because another question is consequences, which you have already answered, is impounding of tainted assets as well as imprisonment. Two broad
Yes.
implications.
Rather, the search at the time of search, they have not even mentioned key impounding of tainted or untainted any asset,
Okay.
and then they can retain. They can then thereafter return.
Hmm.
So normally it should be returned within 30 days. But I have seen in one case the jewelry has been retained
Hmm.
under the guise that okay, if it is required for investigation, if it is not found to be tainted, then we will return. So
Hmm.
more than a year have passed, they have not returned, and I mean, reverse orders have been passed, I would say, but nobody is listening.
Correct.
So these should be taken care by the government at appropriately. That
Right.
right and wrong should be mixed. There should be parameters. There should be robust mechanism to distinguish between the right and wrong at
Correct.
all stages.
Correct. Sir, one of the important aspect is the onus of proof. Uh, I mean, because there is a change in stand where the accused is liable for the onus of proof under PMLA. So, can you explain that concept?
Section 24 deals with that, and there is a gross misconception, lack of clarity with regard to this Section 24. This is generally perceived and as conveyed by the ED authorities that the total onus is upon the accused. Whereas according to my understanding, only one third of the onus has been shifted. Other two-third onus still remains with the prosecution with the ID that they have to prove, they have to show that offense has been done, and so proceeds have been earned from that offense, and only then the third stage, that is the involvement in money laundering, will can be presumed and can be shifted that onus to the accused. So that, I mean, some more better judgments could, I mean, either the amendment specific clarity from the legislation or court made judgment should come to avoid unnecessary harassment of many people in this area.
Okay. So, there is one concept of presumption under the connected transactions. Can you explain that concept under the PMLA law?
Yeah, I mean, that presumption says something like that, that if suppose a transaction has been done and say the transaction was something like that, suppose some theft has taken place, and during that theft some other transactions were also there. So, or there are certain transactions that one transaction leads to the other transaction. So they are saying that even the connected transaction can be then will be presumed to be involved in the offense of money laundering. Suppose the money has been earned, So money has been earned, which has been lent, on which interest has been earned.
Mm.
So I mean that interest earned, which will also be connected transaction. So
Okay.
that connected transaction will be treated as an offense of money laundering. So fruits also of the original
Okay.
transaction will also involved in the offense of money laundering.
Okay. Uh, Sir, one of the interesting question is on the global scenario of this law, because this law also covers cross-border transactions and properties taken or held abroad. So can you
Hmm.
just give some understanding of this, that how does it operate?
Actually, wide powers have been given under the PMLA law. Power of letter rotogatory has also been given, and mechanism has been established that even if the person takes the property outside, then also can be made liable for attachment. Such kind of arrangements have been made, and powers have been given, because under Benami law it confines to Indian soil only. But under this law, property held or taken anywhere in the world can be made subject matter of attachment. So globally speaking, this that is why, and this is not within India only. This is worldwide. The arrangements are like that. You must have heard a few months back there was news in that crime money generated from Brazil, from the politicians of Brazil, have been sent in India. So therefore, the money lying in the bank accounts by whomsoever, even if they were genuine transaction, non-genuine, I mean nothing doing, that will be seen later on. So they were all attached. So this was in limelight few months back. You
Mm.
must have heard about it.
Yes.
So, because similar arrangement is there, so they can also ask India to make attachment. India can also ask them to make attachment of any such property which is alleged to be involved in offense of money laundering.
Okay. Again, another similar question is that what is the grievance redressal mechanism under the PMLA law?
That is again an unfortunate part and unsavory part, that though wide powers have been given, but requisite, it appears to me that requisite infrastructure is still needed to ensure that the right and wrong are distinguished at all stages, and innocent is not crushed or harassed, and early redressal is done, so that even if the property is under some misconception, property is attached under rush to complete the proceedings, this is vacated immediately. Rather, other very harsh provisions have been made that if the moment adjudicating authority makes attachment of the property, the ED has the right to take over possession of that property. So sometimes under this zeal, they takes over the possession, then nothing is done, nothing happens for years altogether. Property gets perished, and I mean damage is done, irreversible damage is done thereafter. Even if the property is vacated thereafter, it's of no use. Financial damage, financial destruction is already done,
Correct.
even in bona. So something needs to be done urgently in this regard.
Right. Sir, I will take up one more question is again on the PMLA law, which says that now the jewelry industry and the real estate brokers are also covered under the law. So, what are the reporting requirements for them under the law?
So reporting requirement is same. Some value has been prescribed.
Mm.
Above that value, if a person is doing a transaction in cash, then or the person who is doing the transaction, that needs to be reported to the agencies. So meaning thereby the transaction which I was doing blindly, that even if somebody is bringing out stolen money, I cannot do it blindly now. I have to be vigilant that the person who is paying the money is a genuine person. The person who is paying the money is the same person, I mean from whose bank account I am dealing. Suppose a person will bring out, give me a DD, I do not know where from his DD come, or give me a check, Mr. X has come, he has given some check issued by Mr. ABCD, whosoever God knows. So I think that will bring out that person in, I mean it will redefine the way we work.
Okay.
uh,
Jewelry industry
so
will have to be very cautious. The outlets.
due diligence will have to be done. So
Correct.
it is a going to be a very big exercise which needs to be done now, because unnecessarily otherwise that jeweler, that outlet will be put into trouble. So dubious transactions will be put to radar, and that person, that outlet will unnecessarily be put to harassment, and he will
Correct.
be also called up for on the ground of possession of crime money.
Mm. Correct. Sir, I mean, for the jewelry industry, it is understandable because he's the person, I mean, the vendor, I mean, the seller is the person who receives actually the money. But if we talk about the real estate brokers, I mean, they are not receiving the money. What they receive is just the commissions. The transaction is between the buyer and the seller. So, what would become as a reportable transaction in such case?
No, what was happening was, in fact, what was happening. that uh, uh, that the person connecting other two persons were this only, right?
Hmm. Hmm.
A person connecting buyer and seller was this only.
Yeah.
So everybody will throw his weight on the middleman. Ki, sir, uh, I do not know. I mean, I met him only. He does not know anything. So now they are saying you cannot act like that. You have to also be acting, with full responsibility.
Okay.
So in nutshell, I would portray the entire thing like this: that the days are the gone when I can do anything with closed eyes and
Hmm.
take the benefit of ignorance under the darkness. No,
Correct.
you know what you are doing, and you should be ready to take its full responsibility. You should be doing your transaction, living your life in that sense only.
All right. So, I mean, even the recently they also added NGOs to this list, not for profit organizations. So
Yes,
this list is an ever expanding list from the government
yes,
side.
yes, yes.
Correct.
Look,
So even all these
my
entities.
opinion, if
uh,
these are implemented clearly, no problem at all.
Correct.
But if law is made harsh and uh, element of fairness is not ensured, the
Hmm.
mechanism is like that, it is not ensured,
Hmm.
then I think it will be disastrous.
Correct. Correct. Right. So even stockbrokers, jewelry units, and NGOs would have to do due diligence like bankers do
Yes,
before they open an
yes,
account.
yes.
Correct.
Very right.
Sir, there is one question on PMLA which is regarding the issue of multiplicity of proceedings. So is it
Yes,
really resulting in curbing of the wrong, or it is just creating a terror?
it has its own purpose. It has its own purpose. We cannot live without PMLA law in country because it is a global requirement from UNO. When this law was enacted, it was in pursuance to the resolution passed at UN, which was made applicable on all member countries. But if we do not understand the objective of this law and the implementation is not done in that direction only, then we will be away from the objective of the law, and then it will lose its purpose. And because focus will be dissipated, then in long run it will be counterproductive. So to have the benefit of the law for the economy is that the focus should always be kept in mind. It should always be kept in mind that only targets are only those who are the real offenders, and not it is not like a fishing net. So if it is used as a fishing net, it will be counterproductive. If
Correct.
it is like a surgical strike, it will be very effective.
Mhm. Right. Sir, I will come back again to some of the questions which have come up on the Benami law. Uh, One of the question was that you already answered is who would be covered under the family definition. Another question
Hmm.
is whether new law is applicable also on business transactions done and assets held by listed companies and other business organization or their promoter directors, or it is brought only for immovable properties held by the person in public service and politician. And if preferably, if you can give some case studies on this.
Hmm. In fact, as told you that it was brought out for that other category which you mentioned, but now they have mixed up everything because law does not make any distinction. Number one. Number two, as far as property is concerned, any property. So therefore, these are being targeted on listed companies also. For example, an infrastructure company creates a land bank, taking help from or by setting up many intermediary companies for creating land banks, whom they call as land bank companies. So these land banks companies, in some certain cases, have been treated as dummy companies and Benami entities, so their land have been attached, and that main infrastructure company treated as beneficial owner. So entire land attached, and these the prosecution proceedings are going on. Similarly, if a listed company, suppose some certain investments have been made by various companies which are in any manner, any relation is shown to say promoters directors, suppose there are employees who have set up their companies and made investment in listed companies. So the allegation is that satellite companies who are revolving around the listed company have been created by the promoters and the Benami entities, and their shares, their assets have been attached. So that is how anything which can bring out a distinction, which can bring out a duality, create a duality, they are subject to attack by the Benami law. Whether the purpose may be justified, purpose of doing such transaction may be justified, not justified, irrespective of that, if any such duality can be alleged to exist, then the allegation of Benami can come in and actions can be taken. That is a scenario which is prevailing in the country.
Okay. Sir, what would be the scenario if the property is acquired by, I mean, getting finance from bank or relatives, uh, whether the transaction is still covered under Benami?
Whether the property is transacted by the relative.
No, no, the property has been acquired through finance from banks or through relatives. Whether it will still be covered under the Benami law, where the source could be identified and
No,
disclosed.
no, 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 no. So long as it is established that it was an arrangement of finance only, not providing the consideration for ownership, there is no problem. So
Okay.
PLLA judgment also says the same thing, speaking through Justice M.R. Shah, recent judgment of 2019 from Supreme Court, that
Hmm.
mere providing finance will not ipso facto lead it for towards Benami. It has to be shown that it was not merely a finance transaction, it was more
Hmm.
than that. It was meant for acquiring ownership rights, real ownership
Oh,
rights. Only that
okay.
allegation of not otherwise.
Okay. Uh, Sir, can you throw some light on how non-residents or cross-border transactions could be hit under the Benami law?
Suppose there is a US company which wanted to make investment in India, but to get the benefit of treaty, it routes its investment through Mauritius or Singapore and sets up an entity in Singapore and Singapore or Mauritius. And in the income tax proceedings, the treaty benefit is denied, say invoking GAR or something like that, on the ground that the entity is in Mauritius or Singapore and nullity, main entity is US. Then consequential action can take under Benami law also. So shares held in India of that US company through Singapore company or Mauritius company can be treated as Benami shares, can be attached. Singapore company as Benamidar and US company and beneficial owner. So they may not be liable for prosecution being not located in India, but their asset can be attached here. So that kind of attempt is possible. So one has to be very, very now cautious. So as I said, the time has come when the right is right and wrong is wrong. Even if the wrong is done, portrayed in rightful manner, that will not be sufficient. Right should be right, wrong should be wrong.
Correct. So,
So
sir, can I say that, I mean, earlier clients used to come to chartered accountants or lawyers only before buying a property, only to understand the capital gain tax impacts from the seller's perspective, or maybe some capital gain exemption when they reinvest the money.
the
But
buyer
now
should
they,
also now
they
the
should
buyer
also
should
consider how the transaction is being structured, and that
yes, yes,
also should be taken into consideration before executing any agreements.
yes, yes, yes. Very right. Very right.
Sir, I recall one of the case of, I mean, famous film star Shah Rukh Khan, where his Alibag bungalow was found to be Benami and attached. Can you,
Yes.
I mean, give insight into what was the case and how the case was decided?
That is how that is what I mentioned in my deliberations also about this case. So the thing is that some company was incorporated, and it was alleged that a company could not have taken land in its name. So therefore, some one of the native was made director of the land, the director of that company, and the land was purchased in the name of that director because he was native of Alibag. And thereafter, only transaction took place. So therefore, this was a Benami transaction done in the name of the company, but whose Benamidar was their gentleman, and Shah Rukh Khan and others were beneficial owners and all that.
Okay,
So that's how, I mean, this kind of transaction was done. So
okay,
Adjudicating Authority has given relief on that. Matter is pending before the appellate tribunal.
okay. Sir, again, some questions on PMLA. I will come back to PMLA. Under the schedule offense of PMLA, Income Tax Act is not mentioned. So, any evasion of income tax, would it attract the provisions of PMLA?
Look, tax evasion as such has not been made mention. Otherwise, on every case, there would have been action by the ED. But the thing to be kept in mind is tax evasion as such is not mentioned, but any other offense done while doing tax evasion, if that is mentioned in scheduled offense and that is proved to have been done by a person, then that part can be covered under PMLA. So one needs
Okay.
to be careful while certain persons who are engaged in issuing bogus bill or doing forgery or something like that. All
Mhm.
those areas are to be hit under PMLA.
Okay, so once they are booked under IPC or CRPC, then those
Yes,
proceedings could be
yes,
initiated.
yes, absolutely. Now you're reached on the point.
Yes, yes, yes. Okay. Mm.
That's it, sir.
One or two more questions, sir. I mean, those which we have already answered, I am leaving it out. Sir, one of the provision, I mean, question is on the provisions with regard to bail, because there has been some amendment which have been made, where earlier it was a cognizable offense and now made, I mean, so can you just make the participants understand on how this has transpired?
Yeah. Look, if the offense is cognizable, uh, uh, if non-cognizable, that means the bail will be obtained and given as a matter of right. But if the offense is cognizable, then the bail will have to be obtained by through the process of law. So it is possible the court may refuse the bail also. So
Mm.
since it is earlier it was mentioned as bailable, now it is that word has been removed. So that means bail will have to be obtained from the court. So it will be a
Okay.
Herculean task. Prosecution is launched.
And sir, I understand that the provisions which have been amended for bail, they have been made so harsh that I mean, the judge himself has to be convinced that the offense has not been committed. So, how would at
Yes,
the initial trial stage the court get convinced that
yes.
the offense has not been
That
committed?
is Yeah, that is how the judgment of Nikesh Tarachand had come to
Hmm.
relax the provision. And I wish the similar provisions which was brought out for PMLA context should be brought out for with regard to Benami Black Money Act, and also with regard to that violation under Section 212(8) with regard to SFI and all that.
Hmm.
So that should be brought out. Otherwise, there will be unnecessary harassment of the people.
Correct. Uh, so we are left with the last question, where a person who has bought the property in the name of his wife, but he himself is not the co-owner, whether the
With regard
transaction is
to
still been.
wife, yeah, with regard to wife, it is not necessary that he should be co-owner. That co-ownership clause is applicable relative other than wife and child. That is lineal ascendant or descendant. That is mother, father, etc., grandparents, and any grandchildren, and brother and sister. So the co-ownership requirement is only there, not here.
Right. Uh,
G.
we have dealt with almost all the questions. Maybe let me just look at if I have left out something.
ये क्वेश्चन है नुपुर जी का. I can construct even when my property is attached. Yes, you can construct. Can I distract to this is interesting question.
Mm.
uh, since I may have some other income too in that property. So since you have income to that property, you keep on earning. Why you want to distract? I could not understand. Why would this person would like to distract in the property? So this probably has not been envisaged by the law. Law in its wisdom has left the rights of usage upon you. Now, if you diminish the value of the property, I mean, I don't know how the law will look upon it, but I could not understand the meaning for this. And if you are having other income, so you can keep on earning that income till confiscation takes place. What is the problem? Once the confiscation is over, whatever the course the law will take place, it will take place. So it is just an hypothetical question. I don't
Correct.
think get into it.
Right.
So
Uh,
I think all are done.
yes, all are done, sir.
All
Uh,
right.
uh, Sir, it was
Thank you very
indeed a wonderful session covering so many economic laws and the interplay between each of them. So, I mean, in nutshell, we have covered the PMLA Act, the Benami Law, I mean, the Black Money Act, and the Income Tax Act, and the interplay between each one of them. Sir, I am really thankful to you for sparing your valuable time and agreeing to address our participant at such a short notice. considering that we were not aware how the things would work out. And despite your busy schedule, you agreed to address this session covering all the laws, because we would have otherwise been looking at multiple faculties. But we were fortunate to have you, where you were able to cover all the laws under the in the single session. It was really a wonderful session with lot of insights on the members, on the provisions of each of the law, and you also very well addressed the queries of the participant. I, on behalf of WIRC, propose a well-deserved vote of thanks to you for sparing your valuable time, and we look forward to have individual sessions on each of these acts in the coming days as per your availability, and we will shortly work out those such session. Once again, thank you. There are responses from participant asking for more such session, and we will surely address that. Ashwini ji, thank you for sparing your valuable time and addressing our members. Thank you.
Thank you very much. Thank you.
Okay.